afternoon, everyone. I would like to begin by welcoming those members of the public and press who are in attendance. A few housekeeping rules before we begin. To use those facilities, these are located back through the main doors on this floor. If there is a fire alarm, please leave the building by the nearest fire exit and make your way to the Cathedral Concourse. If the alarm is an intermittent sound, this indicates a lockdown. Attendees should stay in their seats and await further instructions. Before we start the meeting, please can I remind everyone that this is a meeting held in public and that the audio recording may be made available on the website in due course. Please therefore speak clearly into your microphones. Item 1, apologies for absence.
Thank you, Chair. We have apologies from Councillor Rush.
Thank you. Item 2, does any member wish to declare any disclosable pecuniary interest or non-statutory disclosable interest? No. Item 3, does any member wish to make representation as ward councillor or any of the items listed? Councillor.
No, this is not council. Sorry, Councillor Over. You're either speaking.
It's committee members. The first, isn't it?
Yeah. Yeah, no, that's okay. I see where the confusion is, but it means the committee.
We'll address that confusion in the future meetings. Thank you. Item 4, minutes of the meeting of 23rd November 2023. The committee is asked to approve the minutes of the meeting of the committee held on 23rd November 2023. Do you have a proposer? Councillor Jamil, seconder Councillor Harper. All in agreement? Thank you. Now, before we move on to the next item, we've had a request to move agenda item 4.2 to the end of the agenda. Does committee agree for the item to move? Okay, thank you. Item 5.1. Please can I ask Lucy Battery to introduce the item?
Thank you, Chair. Okay, so the application reference number is 23/00488/full for the erection of 2 detached dwellings with associated hard and soft landscaping at 16 Heath Road in Helpston. So first off, we have the site location plan. You can see here the application site outlined in red. It sits within existing ribbon development on the western side of Heath Road. You have Rice Wood, which is classified as ancient woodland, located to the rear in this area. And on the opposite side of Heath Road, you have countryside and fields extending eastwards. So this is the existing site plan, so it's just a little bit more of a close-up version of like the location plan, essentially. So actually, there is a pond on the application site in this location that is to be removed as part of the development. And there's also the detached outbuilding located here at the front of the site. So in terms of the proposed layout, the proposal is for 2 detached 5-bed dwellings. There'll be 2 new accesses created from Heath Road to serve each property. The design of the dwellings has been amended during the course of the application to remove a large link-attached garage that projected from the front of each property in order that the front elevation of each house would sit roughly in line with neighbouring properties. Note also that the widths of these plots and the separation distance to boundaries are comparable to those of numbers 12B and 14 Heath Road up here. One of the concerns that has been raised during the consultation process is around the impact that the proposed development would have on great crested newts. The species are known to be present in the area, but the wildlife officer at Peterborough City Council is comfortable with the applicant's ecologist's conclusion that no great crested newts will be adversely harmed based on the proposed mitigation measures. In addition to that matter, the proximity to the ancient woodland to the rear is also an important consideration affecting site layout. So at the request of our wildlife and tree officers, the plans have been amended so that the rear 15 metres of each garden, this area here, has been amended to effectively become a buffer zone known as an ecotone. This is so that there is an appropriate buffer and transition zone from the ancient woodland to the rear and the main garden area, but it would also bring biodiversity benefits from the initial planting as well as being colonised naturally over time from the neighbouring woodland. As you'll see from the case officer report, a range of conditions are recommended in relation to this buffer zone to ensure that it is protected and developed successfully. So if I just move on now to the proposed floor plans and elevations, one of the themes running through the objections has been in regard to the design of these properties. As I previously mentioned, the design has been amended to remove what was the link attached garage at the front, so you now have a part integral garage located here. The proposal would use high quality materials with limestone walling and Spanish slate roof tiles, and they've also used architectural detailing such as the coins to create a more attractive appearance. The existing properties along Heath Road are quite varied in appearance, and the proposed dwellings would not look out of place. So this is just the proposed street scene. So you can see that the scale is fairly comparable to neighbouring dwellings. As I mentioned earlier, the existing pond would be filled in as part of the development, so site levels would be adjusted to be in keeping with the neighbouring properties. So just moving on to the drainage plan. During the consultation process, there has been much concern raised by residents around the loss of the pond on site through the belief that it acts as a balancing pond to manage surface water. This pond is part of a historic drainage arrangement, but its role is not as suspected locally and has been demonstrated by a drainage engineer that it doesn't have the characteristics to function as a balancing pond, primarily as there are no flow control restrictions and the exit pipe for the water is larger than the inlet pipe. Attention has also been drawn by objectors to recent surface water flooding along Heath Road as a result of recent storm events. As these events are exceptional in nature, we are unable to attribute very much weight to these when considering the overall drainage proposal, as we must focus on the sort of baseline situation. Just to explain a little bit more in detail about the actual role of the pond. So the pond actually forms part of a watercourse through the garden of 16 Heath Road. So at the edge of the woodland to the west of the site is a shallow ditch that intercepts runoff from that woodland. This then in turn connects into this pipe here, which then traverses under...
Sorry, Chair, if I might, we can't see your cursor moving around. Sort of let you know. So when you're saying here, I can't see.
Try that.
There's a laser pointer. But yeah, sorry. Thank you for
Thank
that.
you to bring to my attention.
Yeah, so I'll start again from that bit. So at the western edge of the application site is the shallow ditch along here, which intercepts rain or surface water from the woodland. This then connects into this blue pipe here, which runs eastwards towards where the pond is currently located. The outlet of the pond is on this side here. Is that right? Sorry. Yeah, it outfalls into the pond here, and then it exits the pond at the other side of the site. Then runs under Heath Road and discharges into the watercourse on the eastern side of Heath Road over in this location. So as a result of the pond being removed, there will be new pipework laid on site to effectively connect the dots. So it's following this red line through here, it would run between the two properties and then connect back up here. So it would continue that pipework then along to the drain on the opposite side of the road. So there have been no objections raised to this approach from either the lead local flood authority or the internal drainage board. So then I believe it's on to the photos. So these are just looking first north along Heath Road and then south. So these are the existing properties that are sited to the north. So you can see they are of a similar sort of stone construction. And then as part of the development, this hedge would be removed, but there would be new hedge planting on this side. So this is the actual application site itself from just the other side of that hedge. So you can see the pond located there. So obviously the levels would be brought up to be more akin to the neighbouring properties either side. And then you've got the ancient woodland to the rear. And then there's just a bit more of a close-up of the pond. And then you have the woodland again at the back. So this is looking south along Heath Road, across sort of the back gardens of the properties. So the red line actually runs roughly along here for the application site, so it would be separated roughly along that line. And then this is looking north towards the other properties on Heath Road. And then this is the pipe at the western side of the site that I was talking about earlier, or the western side of the pond, and then this is the pipe at the eastern side of the pond. Just pop back on that one. So to briefly summarise, there have been a number of concerns raised through the consultation period in respect of various matters as detailed within the officer report. The proposed plans have been amended and additional information provided where relevant during the course of considering the application in order to address those consultee comments. Following a period of reconsultation and further responses from consultees, it is the opinion of officers that there are no outstanding material planning considerations or concerns that should preclude permission from being granted. The recommendation is therefore to approve, subject to the conditions set out at section 7 of the officer report. Thank you.
Thank you for introducing the item. We have 7 people registered to speak on this item. Please can I ask Councillor Ower, Ward Councillor and Parish Councillors representatives Joseph Dobson and Arthur Cross to address the committee. You will have up to 10 minutes between you in which to address the committee. The Democratic Services Officer will let you know when you have 30 seconds left and then when the time has lapsed. When you are ready, if you can please switch on your mic and start speaking. Thank you.
Thank you, Chair. Can I just say...
Just bear with me 1 second.
Sorry?
Are you going to come and join? Yeah.
And is Councillor Rover sitting down from talking now?
And Councillor, are you speaking or...
I would prefer the villagers to put their case forward, but if you have time left, I would welcome the opportunity of 1 or 2 minutes just to effectively summarise.
Thank you. If you don't mind coming and sing at the front, please.
Do you mind if I just stay here, because I think I'll fall over?
Okay, in that case, a mic needs to be passed over to you. Thank you, Councillor Fitzgerald. You're so kind. Thank you. You may proceed now.
Thank you. Can I just state there's an error in the presentation from Ms Butterley that we have not had a reconsultation. And I would like to also to ask, are there any councillors here from rural areas?
I think it's best if you address the committee and you raise your concerns, and
Yeah.
these are the concerns that
I
we
have
will
a
ask the
concern
officers
that
to
there are
address.
no rural councillors here. I think we're being prejudiced by that. Right.
Councillor Ower is one of them.
Yes, but he's on our side.
Oh, okay. Thank you.
Can I just start then? I'm one of the authors of the Helpston neighbourhood plan, so I have an interest in some of the comments I made. I'd like to refer you to page 15 in your documentation here. And the site description, as Lucy has just said, the application site lies to the north of the dwelling known as 16 Heath Road and forms part of the domestic garden. Development along this part of Heath Road is largely confined to the western side and takes the form of a frontage development. There are fields opposite and an area of ancient woodland to the rear. The site is effectively an infill plot. I would argue against that. It's not an infill plot, it's a pond. And it's not a plot of land, it's a pond which has been there for some considerable time. Its provenance is debatable, but we must consider it to be a pond, and as such it has an environmental asset to the village. No reference is made to the pond in the initial description, and I would suggest that presuming it to be an effective infill site is not particularly correct. It is not an infill site in the usual sense that it is a plot of land between two houses. This is a pond between two houses, and the pond effectively takes up the majority of the development site. The other thing that I want to comment on is a little comment that refers to the built environment policy in Helpston's neighbourhood plan. And it says the proposed dwellings, both having the same number of bedrooms, would not be a strong reason in and of itself for refusing the application, particularly given the mix of dwelling types and the size of this part of Helpston. Furthermore, this part of policy A2, which is the criterion B of neighbourhood plan, the word is should rather than the mandatory must. Now, unfortunately, that seems to dismiss what we understand should to mean. I'd like to refer you, just for an example, to policy LP20. And in it, there are many references to the word should, and I'd just like to give you a few examples. Existing frontage hedging must be retained where this is absent. Evergreen hedges species should be used. New building designs should incorporate boundary walls, railings or fences with formal evergreen or deciduous hedging. Any development should respect the linear form of Ashton. This is part of this policy. And there are innumerable examples where the word should is used. Now, my interpretation or understanding would be that should requires a criteria to be observed. We are looking at two houses which shouldn't be the same. So the criteria here, as far as the policy in Helpston's neighbourhood plan, is that the two houses proposed on this development should not be the same, should not have the same bedrooms, perhaps not the same physical appearance. That should. There is no reason why that should not happen. And in fact, no reason has been given for that word should to be dismissed so that the two houses can go ahead. So this is my argument, that there is a policy in a neighbourhood plan which was passed by yourselves and more recently than the local plan, so you have full understanding of what the neighbourhood plans are about. So this is a policy that's in our neighbourhood plan which should be given exactly the same weight as any policy in the local plan. So when you're looking at this word should as it applies to policies in your local plan, are you going to dismiss them? Are you going to allow them to be negated? If so, it means most of the policies in your local plan cannot be enforced. What I'm asking you to do is to look at this policy within our local plan and look at it in its spirit. We don't want a plethora of houses which are the same in our village. We would like some difference. So if you can consider that, I will be obliged. Thank you for your attention.
Mr Chairman, councillors, I'm Councillor Cross from Helpston Parish Council. My position is more of a technical, a help really, I'm hoping, to the councillors here about the way that this application is actually unsound. If we start and look at the application itself, which is signed by the agent, he's signed a statement of truth, basically, and he said that I confirm to the best of my knowledge any facts stated are true and accurate, and any opinions given are genuine, I should read opinions of the person giving them. And that is relied on by the case officer, who says we have to accept these documents in good faith. And my argument is that you don't, that the case officer didn't. The officers did not have to accept this in good faith because it doesn't stand up to scrutiny. But first of all, the word, I'm not even sure it's form PF04 because that doesn't appear on the form, but actually use the words genuine options. So he says basically, any facts stated true and accurate and any opinions given are genuine options. I mean, formalistically, I know it's a technical thing, but there's a fault on the form itself. And then you add to that things like, are there any trees on land adjacent to the site? No. We've got rice wood at the back. Okay, we can discern that, and today we know that. Does the proposal require any diversions or extinguishments? Well, we've heard today the case officer saying the pond's going to be filled in. But does that involve any diversions and extinguishments? Yes. But we've got an applicant, who's agent, who says no. But actually, to fill that pond in at the moment, because it's governed by a drainage deed and benefits other properties in Heath Road, not just the wood and not just the ditch at the back, it has enforceable obligations in there, then there will be diversions and there will be extinguishments. And the applicant hasn't approached the people that are parties to the drainage deed. The City Council itself, as the local highways authority, is a signature to that deed. I just worry that this could end up in embarrassing the corporate City Council, because there's other agencies involved, like the local highways function, that you could actually be party to something that actually ultimately is going to be unlawful. Filling a pond in without properly negotiating terms with the persons entitled, the parties to that agreement, which includes the local highways authority, would be breaking the law. Not criminally, but breaking the law nonetheless. I'm just anxious that our councillors, we've been anxious that that didn't happen, and we've put representations in. I'm just anxious that the councillors today also don't risk that. We've got a site area. What is the measurement of the site area? 1,504 square metres. But actually, we don't know what the extent of the site is, because there's an application before the land registry disputing a strip of land, and it's been allocated a new title number. And if I apply for details of that on behalf of the parish council, which I could then share with you, I'm told it's a pending application. So we don't actually know who the owner of that is. Which brings me to the other point then about certificates of ownership. The certificate, my understanding is that the procedures basically said, council procedures, that if you look on the website, that a copy of basically a copy of the notice must be sent with the application. But the notice has only just appeared recently on the website, so on the portal. So only one certificate should be submitted, but we've got two. We've got a certificate A, and now we've got a certificate B. Certificate A, where statement of
About
truth.
30 seconds left.
Certificate of truth. And there's lots of other anomalies in this. And there's been a lack of engagement, and that's been the fatal mistake. The applicant didn't engage at the outset or before this application. She didn't do a pre-app. And so basically it's, the whole application is unreliable, and there's been no active case management. There's been a passive case management, but no active case management.
Thank you for your presentation. Before I allow committee members to ask you any questions if they may have, I think it's important that I put it to you that this committee is impartial, it's non-political, and we make decisions as we see the presentations and are asking the questions. So it's non-political, non-biased, so just, rest assured that we wouldn't be biased in any way. Now, members, do we have any questions? No? In that case, you could take a seat back in the gallery.
Thank you very much, Chair.
You're welcome. Thank you. Please, can I ask Annabelle Tyre, John Donny and Richard Assel as objectors to address? Is it Richard Astor? Okay. To address the committee. You will have up to 5 minutes between you in which to address the committee. The Democratic Services Officer will let you know when you have 30 seconds left and when the time has lapsed. When you are ready, if you can please switch on your mic and start speaking. Thank you.
Thank you, Chairman. I'll be brief. This isn't about an infill site. It's not about a disagreement between neighbours. This is about faith in planning policy. This application is clearly non-compliant in terms of the local neighbourhood plan. The officers have acknowledged that. And we urge the committee to recognise that and not set aside a neighbourhood plan that has had so much endeavour put in it by the local community. It's gone to referendum. It's been endorsed by Peterborough City Council. So faith in the planning process is so important for communities, and we do have faith in this committee, absolutely. And we have faith that you will recognise that when a planning application is compliant, it should generally be passed. When it is non-compliant, as this is, and that's acknowledged by the planning officer's recommendations, it's non-compliant on that specific aspect of the local neighbourhood plan, we would urge you to uphold planning and not allow non-compliance to go through because of this question of whether should is the right word or not. If this is about communities' trust in the system, and we really need that trust for the future, for other planning applications, so we don't feel that non-compliant applications can sail through. It's a shame that the pictures didn't show just how big this pond is. It occupies the whole of the site of the two houses. It's not some small garden pond. It has historically played a huge role in the drainage of the area. And as my colleague John is about to say, there are covenants on this land signed by Peterborough City Council which specifically recognise that it should not, nothing should happen to it at all because it stores storm water. That covenant is in place. Those who are signatories to the covenant will continue to uphold it. But we would urge you as a committee to stand by the community and stand by planning policy and not allow this application. Thank you. John.
Thank you, Chairman. I'm just, as Richard said, just following up on the flooding issues, the risks to that. So there's been extensive flooding in Heath Road previously, back in the 60s and 70s. Properties were flooded, water up to about a foot deep in places, and as a result, this solution that's been described was put in place by the council, and as mentioned, a covenant put on it to protect that going forward, and the council is a signatory to that, and as a result, the council is therefore obliged to support us in upholding that, to ensure that nothing happens there. I'd just like to bring some attention to the recent storm we had, Storm Babette. A significant volume of rain that fell. We had flooding down Heath Road. One property almost flooded, but it didn't. The drainage solution we have in place worked. Now, throughout that storm, I actually videoed the water flowing out of the pond from the pipes into the ditch from Heath Road, and also likewise water going into the pond. And what we found was, or what I found was, substantial volumes of water flowing out, but nothing coming in, or very little coming in. And the reason for this is because about 30 years ago, Milton Estates, who owned the Rice Woods, actually put their own flooding prevention system in place. Some ditches that fed the water away from the properties. As a result, the rear pipe is now pretty much redundant. And the proposal here is to actually connect the two pipes together, and that will resolve our flooding issues. That will not. That will do absolutely nothing, because the water that we saw flowing out of the pond actually comes from the properties to the south of this development. There's actually drainage in place there, secondary set of drainage, that feeds that water to that pond, and it comes out. So the pond, contrary to what's been said by the planning officer, is a balancing pond. Water flows in, it balances. When it reaches high enough level, it flows out. Now that flow continued for 2 days after the storm, okay? And then we had no additional rain at that point in time. So it clearly shows it is managing storm water, okay? The hydrological report that's been submitted focuses solely on this as a solution for mitigating the risk of flooding. As I say, unfortunately, because of what I've just explained, this is a fundamental flaw.
There's 30 seconds left.
Okay. It's a fundamental flaw. You know, the connecting the two pipes will just do nothing for us. It will actually probably make the situation worse. I just one last final point is regarding the flood risk assessment report that was put in place. This has not been written by a flood risk engineer. It's been written by the applicant's agent. As far as we're aware, it's not a flood risk engineer.
Thank you for your presentation. Members, do you have any questions? Yes, Councillor Sharp.
Thank you, Chair, and through you.
I just wondered, you made the comment a couple of times in relation to non-compliance to the local plan, and I think you mean LP2. Can you just clarify the exact detail of what you mean by that and how it corresponds? Because I'm assuming it's relating to section A of paragraph A of section 5 of the principle of development, where it says significant part. So I just wondered if you could expand on that for us.
Yeah, excuse me one second. It's non-compliant with the neighbourhood plan. The neighbourhood plan states very clearly that where there are a development of 2 or more dwellings, then they should provide a range of dwelling sizes in terms of the number of bedrooms, so they shouldn't be identical houses. So it's a very clear policy, it's very clearly stated. This application is for identical 5-bedroom houses, so therefore it's non-compliant with the neighbourhood plan. And we see no reason why it couldn't be compliant. Why has the applicant not gone for a compliant application, and why has the planning officer recommended a non-compliant application? And I think the point here, if I may, is about faith. You know, neighbourhood plan, whether it's urban or rural, whether your constituents live in a village or place that are upheld by their councillors. And I think this is the fundamental point of principle. If they're not upheld, then what else is not upheld? And as Arthur said earlier, there's sort of sophistry about the fact that it uses the word should rather than must. I mean, that just undermines public confidence in the planning regime. That was a neighbourhood plan that went to referendum, that was endorsed by you guys in this council chamber. So please uphold it.
Yep, go ahead.
So if I'm understanding it, thank you for the clarity. So if I'm understanding you correctly, your balancing premise is that because the local plan uses should and not shall in this instance, that you're suggesting there shouldn't be some flexibility, which is potentially the reason for using the word should. Is that where you're coming from?
Personally, I think the word should is very clear. It should be 2 different dwellings, and it isn't.
Sorry to interrupt you. Can you come closer to the
I'm
mic?
sorry, yes.
Yeah.
Sorry.
Thank you.
The question was my interpretation of the word should, and I wouldn't venture an interpretation, but the policy says that there should be 2 different sized dwellings, and there aren't. I think that's pretty clear.
Any more questions? Well, I have a question. From your presentation, you were concerned about the drainage and ecology. There's been an assessment given to you, and I've read the report, and officers have raised concerns, but they've discharged the concerns when the assessment or the reports were given to them by the applicant. What's your view about that?
My view about... Sorry, I didn't quite understand the question.
Assessment is in favour.
The assessment
So what's your view about the assessment?
I think the assessment fails to take into account a number of considerations, particularly groundwater as well as rainwater. So we have, first of all, the size of the pond, and I do think it's very disappointing that the council weren't given a sense of that from a photograph, that this isn't like my garden pond where you can get a couple of fish in. This is a very big pond that covers both the dwellings that are proposed. So it obviously contains an awful lot of water and stores an awful lot of water. So the key question is, where does that water go now? There are 2 much smaller ponds proposed as ponds and wildlife ponds at the back, but they will be lined so they won't absorb groundwater. So the fundamental question here is, where does the water go? And the answer is, it goes into the ditches. It's stormwater, it flows out. And I think it's very important to recognise that there is an existing covenant on this land that Peterborough City Council is a signatory to, which states that nothing should be done to take away the role of the pond for it to store stormwater. And this is exactly what this application does. It takes away the role of the pond to store stormwater. Peterborough City Council hasn't objected to that covenant. It's actually signed that covenant. It is a signatory to that covenant. So again, it goes back to faith in policy. If you have covenant on land, how do you just set it aside at the will or whim of a developer? So this is, as I go back to it, the point here is all about principle. It's all about faith in the planning system. And we absolutely hope very much that Planning Committee will recognise that and recognise that if we set aside policies, and particularly I think this point about the local neighbourhood plan, why isn't it compliant? Why can't they build a smaller house and a larger house? So why aren't we encouraging them to be compliant rather than accepting non-compliance?
Sorry, could I...
Oh, you want to respond as well, yeah? Okay.
Yeah, just very briefly to your exact question. The Peterborough Drainage and Welland and Deeping Internal Drainage Board, yes, they didn't object to that because what they saw was the two pipes being connected. Okay, well, as I tried to explain, that is redundant. The water is not coming from the back and will feed into there. That is just a redundant solution. So the information that they have seen is not correct. The water is coming from other properties from the south into the pond. And that's not factored in that hydrological report. So they've made their assessment on false information, I'm afraid.
Thank you. Any more questions? Councillor Sain.
Sorry, just to clarify, we did do a site visit and we did get to see the size of the pond. There's been mention of the pipe coming in from the rear of the property and it going out. But you mentioned these other properties in the south. So from our site visit, I couldn't see any of the pipes coming into that pond or exiting. So the only thing I would say is if you're saying there's less water coming in, would you say that then that is surface water going into the pond?
Yes, it's storm water that's coming in, but there is drainage in there. There's no specific pipe, so it's underground drainage that was put in years ago to help feed that water down towards the pond from those neighbouring gardens. I can't remember how many it is, but a substantial volume of houses, maybe about 5 or 6 houses. 6 houses, there we go.
Excuse me, no. He needs to respond, not from the gallery. Thank you.
But yeah, I've clarified there, so hopefully that helps.
Just
Do you have a follow-up question, Councillor Sain? Yeah, go
I
on.
do, sorry, I'm just trying to find the section in the report where it says about the deeping, where it says about approval. It also mentions before approval is granted, as in building can commence, there will be a full...
That Councillor Sharp could ask his question.
Sorry, yeah, it's just a point of clarity relating to Councillor Sain's question, because you answered his question about saying about there was drainage back from the other properties, which we heard from the gallery. But I thought your colleague said earlier that the pond was lined, so I'm just trying to understand. I misunderstood that.
The pond isn't lined. The proposed, the two new ponds will obviously be lined.
So your statement was that it was not lined as opposed to lined.
It's not lined. And the point is, if you look at the covenant,
That's
and we
fine.
keep coming
Answer
back
the
to
question.
that,
Thank you.
they are the houses that are covenanted to this are the houses to the south of the property. So that's exactly backs up John's point.
You want to follow up? Go on.
If I just come back, yeah, just because you mentioned it again, the covenant piece, I'm sure I've read somewhere in the report from the officers that covenant is not a material consideration in planning. Is that your understanding? You accept that in the report?
I accept that the covenant says that the pond stores stormwater.
That wasn't the answer to my question. Thank you, Chair.
It wasn't.
Councillor Sain, have you found your section?
No, sorry, Chair. Well, it's just where it says about well and deep, and it does say that new pipework shown on the drainage drawing will require the board's consent, and further on it does say something similar. I was just trying to find that section where it said that. So before building work can commence, they would have to get approval about the drainage.
Wouldn't that come in a debate? Or is it, that's not a question, is it?
So it's just a
question to the
see whether
officers.
they-
Yeah, okay.
Yeah.
Thank you very much for your presentation. Before you go, I think Councillor Sharp has taken my word. We as a committee are restricted. Please, can I ask John Dickey, the agent, to address the committee? You will have 5 minutes in which to address the committee. The Democratic Service Officer will let you know when you have 30 seconds left and then when the time has lapsed. When you're ready, if you can please switch on your mic and start speaking. Thank you.
Mr Chairman, thank you for allowing me to make a presentation to the Planning Committee today in support of my client's development proposal at Heath Road, Helpston. In situations when we're at committee with an officer's clear recommendation for approval, I wouldn't normally address members, but given the degree of attention that this application has unexpectedly brought about, I thought it sensible to make myself available to the Planning Committee today to be able to respond personally to any questions that councillors may have. The genesis of this planning application has been well documented in the officer's extremely comprehensive report to committee, and I don't think it either necessary or helpful to expand on that report, as my client and I concur with all of its conclusions and recommendations. I would also make the point that we are entirely agreeable to the planning conditions as proposed by the case officer. A bit of background, Mr. Chairman, if I may. It was the autumn of last year when I was first asked by my client to assess the development potential of her property on Heath Road. I'm asked to look at a great many sites in the course of any given year, and as you might imagine, some present more by way of opportunity than others. From the outset, I take an often quite brutal devil's advocate approach to offering my first impressions. This process involves identifying constraints and opportunities. It's a bit old-fashioned in this day and age, but I find it hugely effective. Most of the headline opportunities for Heath Road were obvious to me. The site was located beyond the Helpston Conservation Area, inside the village settlement boundary, and had a width of side garden that was clearly capable of accommodating 2 detached houses of reasonable proportion. In principle, a classic case of infill development, or, in planning parlance, development in an otherwise built-up frontage. 2 particular constraints were equally obvious when inspecting the property: the pond, being a potential habitat for protected species, and the possibility of the body of water performing some kind of hydrological function. The proximity of Ricewood to the west of the site didn't raise any particular concerns at the outset because the land in question was already a residential garden. The development of 2 dwellings wouldn't present any change of land use whatsoever. There were 2 established but unprotected weeping willows to the eastern edge of the pond, but I dismissed these as a constraint to development as their longevity was severely compromised. I know enough about trees to be quite certain that any arboriculturalist would have classified them as yew, and that means that their condition is such that they can't realistically be retained as living trees in the context of the current land use for longer than 10 years. Further into the planning process, this view was confirmed by our consultant arboriculturalist and indeed the council's own tree officer. Disrupting the surrounding pattern of development, and more particularly the street scene, is always something to be considered as a possible constraint to any development. In this case, no such sensitivities were evident. In recent times, several detached stone houses had been developed to the north of my client's property. 2 further carefully designed stone houses would simply represent an extension to the pattern of development already established. The potential for archaeological issues seemed unlikely, and it certainly didn't occur to me that the pond might be thought of as some kind of heritage asset, especially when an examination of the planning history for number 14A revealed that a significant portion of the original pond had already been filled in to facilitate that development. Thank you again, Mr. Chairman. If councillors have any questions regarding my client's development proposals, then I'll be more than happy to assist.
Thank you for your presentation. Do members have any questions? Councillor Hogg.
I just want to ask, in terms of the neighbourhood plan, this discussion around the fact that the properties need to be different, why was it that you decided to ignore that?
I was well aware of the way in which the neighbourhood plan had been constructed, and I took exactly the same view as to the use of the word should as the case officers had. It doesn't compel you to, as far as my understanding of the English language is, to have 2 different dwellings. Therefore, we decided to go with 2 handed versions of the same house type.
Thank you. Councillor Jamil.
Thank you, Chair, and through you. One of the objectors earlier stated that there was some dispute over who owns some of the land. Can you shed any more light on that? Do you own it? Are you hoping to own it? Why would they raise that as an issue?
Well, I don't own any of it. My client does, but there is a strip of land to the north of the site and that is the subject of an adverse possession claim by my client. That isn't, as far as I'm concerned, a planning issue. It's not a material planning consideration. Therefore, I don't believe it's germane to the decision-making process.
Thank you. I've allowed Councillor Jamil to ask that question, but it's not a material consideration. We'll take that on board. Any further questions? I have a question. Again, going back to the Helpston neighbourhood plan, majority of the objectors say that you didn't adhere or didn't give any weight to it. Now, they refer to should. So am I right to understand if it'd been must, then you had to comply with it because it should, it gives you a bit of room of flexibility? What's your opinion on that?
I agree with exactly what you just said. If it had said shall or must or has to or some other verbiage, then we would have given it serious consideration. But the word shall really doesn't force the issue, in my view.
Thank you. Any further questions? Thank you. You may now return to the public gallery. Right, members, do we have any questions for officers? Councillor Harper.
Yes, thank you, Chair. I've got a few, if you don't mind. I can do one at a time if you tell me how you want to go with this.
That's absolutely fine.
I need clarification, please. This is probably mostly from the officer and our legal officer, that land ownership is not a material consideration. The covenant, I'm confused on that because if we've signed it, as has been said, is that then not a relevant matter and we should dismiss that? We'll go with those two. Oh, so the other two are, as has already been said, and I'm quite right, you know, I have a tendency to lean this way, is we have neighbourhood plans, we have local plans. And in this case, we are being effectively told to ignore one of them. And I'm just wondering what your opinion is on why do you think we should ignore that neighbourhood plan, particularly in the should, would, could, is area, please. Thank you, Chair.
Thank you.
Yes, oops, quite right. We're not concerned with ownership at this committee or covenants. They are certainly very strong civil matters, so there is an alternative remedy in a different arena, different court. But we cannot take those into account. We must concern ourselves with planning matters only. Sorry, but that's just the shackles we wear. Did you say there was a third point about the local plan?
If I may, Chair? Yeah, just to clarify, the final point was your view, your professional opinion on the fact that in this case, should is being seen as, well, maybe, rather than must.
This takes me back to College of Law days in Guildford, where we were lectured by Mr. Passingham, one of the tutors there. If it means must, it must say must. Why anyone drafting a statute to use the word should is totally beyond me. But it should say must, if someone's going to disagree at the back there.
Should it must say must? Sorry.
Yes. Yeah, okay. It's one of those funny things you live with all your legal life.
Okay.
Yeah.
Thank you, Chris. Chair, you want to go to somebody else and I'll come back? Or do you want me to carry on?
You're not allowed to speak now because this is a session where we have a debate. No, you're not allowed to. I'm sorry. Thank you. Anybody else? Councillor Sharp?
Yeah, I wonder if we could skip to the slides where you were showing the revised drainage layout. Just a point of clarity, because I don't know whether it's the colour coding that you used because you've used the new drainage in red, or whether you're implying that blue surface water is connecting to red foul. When you talk through the new drainage connections to effectively supersede the pond.
The red line that I'm just tracking, that hopefully it's showing, tracking with the pointer now, this would be the new pipe work that will run through between the dwellings and then connect up to here, and it will join the existing pipe that then runs in a south-easterly direction underneath Heath Road and then into the drain opposite.
Thank you. Yeah, so just to clarify, you're using red as a description for new as opposed to foul, which would be the normal red classification, correct?
So the foul, as I understand it, is these red, like, solid lines from the properties, and the dashed red lines is the...
It's new surface water.
Yeah.
Thank you.
Thank you. Councillor Hopper, you want to come back?
Yeah, as I said, I've got a few. So I just wanted some more clarity, really. Question for highways. Again, it was mentioned, although there is a statement from highways, and it doesn't actually relate, or I couldn't see that it related to any effect of flooding. So are they content that flooding will not take place
if this pipe is joined up, is the road safe from flooding? From this particular development, not necessarily rain's rain, but from overflow from the land. That's
Thank you, Chair. Through you. The risk of flooding from the development isn't something that Highways would look at. That's covered by the lead local flood authority.
Councillor Hogg.
So I just wanted to come back on this should have, could have, would have definition. So my understanding would be if it was may, then that's kind of like it's an option, but it's certainly up to interpretation. But should is almost like a must, but it's covering off that there may be circumstances whereby exceptions can be brought about. So would that be a correct assessment? That should is kind of quite a forceful word. It's kind of saying it should happen, as opposed to it absolutely has to, without any exception. So it's kind of giving you a way of having exceptions if need be, but almost you'd need to demonstrate what that exception was.
Yeah, I'd say that was a fair assessment. I wish people wouldn't say should when they mean must, but must means must. You must not do that.
Thank you.
But there's a kind of a hierarchy, or
Yes,
is it must? Should comes slightly
It's a
below
very strong
that.
word. It's a very strong word.
It is
should.
quite a strong word, isn't it? Yeah.
But it can be qualified, I would
Okay.
say.
Councillor Hogg, if I just interrupt, I think he's given his response, and I think a further question wouldn't be appropriate in my way. And I think you want to come in, Phil?
Yes, thank you, Chair, through you. So, policy A2 in the Helpston Neighbourhood Plan has got 4 criteria. Now, 3 of those criteria either say will or must. The criteria that we're talking about here says should. So clearly, the writers of the plan have used those words for that reason. And I would agree with our legal officer here that should, in this sense, means it will be good to have this, but it's not absolutely mandatory if there are reasons why we can't, or other reasons that indicate against it, whereas must is mandatory. And in this case, Lucy has clearly set out in the report, there are circumstances to not go for 2 dwellings of different sizes.
Thank you.
Chair.
I'm not going to have any further debate on this point. I think it's been addressed by the legal officer. Again, we're going to give our own opinions, and I'm not happy for that. Councillor Sharp.
Well, it was related to that only because I'm slightly confused. I just want to get a point of clarity from the legal officer, because he did make the statement that I wish people wouldn't use should when they don't mean it, when they mean must. But we're not implying that the local plan said that, are we? Because we don't know what the intention was in the wording. But of course, Mr. Moore has now clarified that, I think, by saying that it didn't mean that. So the legal officer's statement was a statement of opinion, not fact of the local plan. Is that right?
Oh, thank you for raising that.
Is that right?
Is your question relating to this issue or something different?
It's to do with the planning officer's decision to dismiss that element. The point I was trying to make was the word should, for my mind, would mean that there would be a need for an exception. So I'm trying to work out why the officer decided that this could fall away, is the point.
Councillor, what I'm going to say here, that we've got officers here, we've got a legal officer here, and they have a purpose why they're sitting with us, and they've given us their explanation. I think we should take their explanation or their definition on board. That's
exception when interpreting, and I won't say the word, when interpreting policy in order to reach your conclusion for approval or recommend to approve. So what is the rationale? Because what I'm hearing from objectors and others is that actually the principle of development may be accepted. So, for example, if the applicant said one house is now 2 foot smaller, that seems to solve the problem. I'm being quite flippant about that. So what is the reason that it's gone for approval, bearing in mind that local plan? And if you could answer that, then this conversation stops.
Thank you. If you could respond to that.
Yeah, thank you. Through you, Chair. Yeah, I think really my thinking behind it was obviously that there is already a mix of dwelling types and sizes in this part of Helpston. And also, obviously, you have the allocations coming forward in the future, which obviously have the scope to accommodate much more of a variety of dwelling sizes.
Okay, I have a question. I don't know if it's clear on the street view. The properties to the right, were they constructed recently? Are they the same? Are they handed? Are they different? And were they constructed while the local plan, neighbourhood plan, was in place?
Yeah, so these two properties here that I'm showing with a laser pointer, as I understand it, permission was granted for them in around 2011. So it would have been before the current adopted local plan and the neighbourhood plan.
Do they differ in any significant way than the proposal is? Because I heard you say it's an extension to the continuation of the street scene, which was my understanding from on-site.
I'm not sure in terms of the actual internal layout of them, but obviously in visual terms, I felt that there was quite a lot of similarity in between those and the proposed dwellings.
And sorry, Chair, if I may, just one final point. And in terms of the principle of encouraging development, that is part of policy. And again, does one out-trump the other in terms of the hierarchy between our local plan and the neighbourhood plan? And was that part of your consideration or deliberation as well?
Yeah, so both are part of the adopted development plan. Obviously, planning it is very much a balance. Obviously, as I've gone through the officer report, there's many different considerations to weigh up, and obviously the ultimate decision has been one to recommend approval.
Thank you. Got a final question? Okay.
I can't see, and so I'm just asking for clarity. There are all the objections that have been raised in statutory consultees and others have all been addressed, and there are no concerns. Is that correct? Or did I miss any? The only outstanding objections from the statutory consultees or technical consultees would be from there was the Woodland Trust and the Forestry Commission, but obviously that is explained in the report, and I believe it's so that has basically been addressed through the use of or introduction of the ecotone and buffer zone area at the rear of the site, and our tree officer has been reconsulted and gone through it all in detail and has no objection.
Thank you for that. Any more questions? Councillor Sain?
Yeah, sorry, just to pick up on what I was saying earlier. So if this was granted, am I right in saying that before it could commence, building could commence, that the drainage strategy and flood risk would have to be submitted, assessed and approved before any building can commence?
Yeah, so there's not a separate condition relating to the drainage, but obviously the drainage strategy does form part of the approved plans. And then the IDB matter, basically what they'll have to do is before they actually implement the drainage strategy, they'll have to seek consent from the drainage board, because obviously they're discharging into their drain ultimately. But that's separate to the planning process.
Thank you. Any further questions to officers? Councillor Sharp?
Thank you, Chair. Very quickly, just to carry on the drainage theme, the bottom of the section of the officer's response on drainage, we talk about the recent storm event that some of the objectors have referenced. I wonder if officers can clarify how high above the baseline situation that proved to be, and what the one in year event was. And the second part of my question is a note that you state that officers aren't in a position to be able to object on the grounds of the impacts of such storms. It's just an unusual wording. Is that because you're not able to under the guidance, or it's almost as though there's a hidden meaning? So I just wonder if you could explain that a little bit further for us, the reason for that comment.
So in terms of the storm events, obviously they were an exceptional event. So from our point of view, we have to consider it on the basis of what the baseline situation would be. See, the drainage team, they are well aware of the concerns of residents on this site. I believe that one of our drainage colleagues was actually out on site shortly after one of these storms. Obviously, they've reviewed the submitted information and don't believe that there's actually justification to object to the application. So obviously, we can only really go based on what their professional opinion is on the drainage side of things. In terms of what sort of year event it was, I'm afraid I wouldn't be able to tell you.
Thank you. I think we've had enough debate on this. Any more questions before I proceed further? No? If there are no more questions, I will move to debate. Who would like to start the debate? Councillor Hogg, is it you? Councillor Harper, thank you.
You forgot my name there, Chair, through you. Thank you. Extremely difficult one, and I appreciate the time of everybody coming along today to put their points across and cause us to ask questions of ourselves and officers. I think we've had the legal clarification and we've done that now, and I accept that land ownership, covenants, etc. are not relevant matters, and so I have to dismiss those at this stage. The use of this as a holding pond or balancing pond, obviously with two different opinions on this, and I appreciate the opinion of local villagers, but then I also take on board a qualified opinion that this is not a balancing pond, nor has it got any archaeological history to speak of. Neighbourhood plan, local plan always worries me when, as a previous chair, when people start to push the boundaries, although obviously it's not set in stone, although it is agreed by council and parish councils, but there has to be some amount of flexibility if proved necessary, and that's what we're here for, to take on that sort of like grey area to decide for ourselves. The two houses that have been shown that are looked at the moment, they look pretty much identical from the view. They may well be different from the side, and to do that again, sort of that takes that away from me. It takes away the fact that they're, in the plan it says they should be different, because next door they're not really different. Slightly different, I agree, but not really different. So I don't think that's got a lot of weight in it itself. I do have concerns about water on the road, but if the Drainage Board are happy and are saying they're happy and they've been on a site visit, as we did, I noticed in the report they did actually go out and have a look, then that's really, I have to accept what the experts are saying in this. And so for that reason, although I do certainly sympathise with the residents in the village, because the neighbourhood plan appears to have been, has been put aside slightly because of this identical houses thing. I don't think that is the major thing, although that's been brought up. I think the major thing is flooding and use of the pond. But that has been answered, and for that reason, I said I'd remind people, Chair, if you didn't mind, that planning is, it's a yes, unless there's reasons to say no. It's not a no, reasons to say yes. And all the officers and all the experts have said it's a yes. So on that basis, I will be supporting officers' recommendation. Thank you.
Thank you, Councillor Harper. Councillor Fitzgerald?
Thank you, Chair. I'll return to my previous points in order to tease out basically what Councillor Harper's just said in many respects. It's a difficult one, and I think local residents have the right to come here and make representations to the committee, and everybody's view is welcome, and it is a difficult thing that we have to make a decision on, which is why I asked the question about A, the precedents, and B, the report itself. If there were lots of red flags in this report going no, 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 and nobody likes it, but I haven't found any. That's the problem. So if this was refused and went to appeal, I believe we would lose that appeal on the basis that this has been considered in the round and there are no real objections other than the very valid ones from local people, and we accept that. But I would be minded on this occasion to be supporting this application, even though that might be a disappointment for some people here today, because in all honesty, if I were to do otherwise, I think I'd be making a mistake.
Thank you. Councillor Hogg?
I think this is very much one of those tussles between the head and heart. I think that it's really important that we encourage neighbourhoods to come forward with their own plan, and I have to say that it does seem like this has been squeezed through in terms of a definition of a word. My interpretation of the word should basically means that it must happen, but we are giving you a bit of leeway in exceptional circumstances. I'm not entirely sure that is quite got over the line for me, I have to say. But in terms of kind of, we're talking about the round here, the covenant thing is something that it's not a matter for this place. And I would suggest that maybe objectors may wish to take that particular aspect of this situation further and have a conversation in another place. We can't use that in any kind of determination factor. What I'm left with is I was really sitting right on the kind of the knife edge, I have to say. And the reason why I held back in talking, because I really wanted to kind of hear what other members of the committee had to say on the subject. And I think in the round, I do find myself in a place where I can't go against officers' position, even though my heart is saying that actually it should be with the residents. So yes, that's where I am. Unless other members have got other arguments that would pull me back over again. So, as I said, it's a very knife-edge thing.
Thank you, Councillor Hogg. Councillor Jamil?
Thank you, Chair. Whenever we get objectors, the passion comes out, and rightly so. But unfortunately, in one of those situations that we're here today, for me, the arguments are the role of the pond itself and the flood, and I think when you read through the paperwork, those are adequately explained, so I will be supporting officer recommendation on this one.
Thank you, Councillor Jamil. Councillor Jones?
Thank you, Chair. I was on the site visit last week. I saw the area, and at that stage, it was an open shut case. It was just approve. Listening, as Jamil has said, to the objectors, you think, and then of course you took looking at the 3 of the 4 criteria. I split it down as 3 need to haves and 1 nice to have, and the nice to have, which is the should aspect of it, doesn't really hinge on it for me. I think it's in an ideal world, it would be lovely to meet that condition, but we don't live in an ideal world. And also, I'm minded looking at the flood reports, and I have to agree with Councillor Fitzgerald. I think if we went against this, I think we'd end up being called to account on appeal, and probably quite rightly. So take the heart aspect out of it. My head is minded to go with the officers and approve this, because I see no reason on the flood basis that it will exceed the amounts that we're talking about.
Thank you, Councillor Jones. Anybody else who would like to contribute in the debate? Right, I can't see no more hands raised. In that case, can I please ask for a proposer? Councillor Harper.
Thank you, Chair, and through you, I propose we go with the officer's recommendation, subject to the conditions noted. Thank you.
Thank you. Do we have a seconder? Councillor Jones? Right, now we're going to go to the vote. I think we've changed the way we're going to vote. Right, so first of all, I think it's all those who are in favour. It's the green card, if I'm right. Yeah, there we go. Against? Any abstentions? And if you could just read out the voting for me, please.
Thank you, Chair. So It is at 9-4. That's unanimous. Unfortunately, Councillor Bond was unable to vote because he was late to the meeting. Thank you.
Thank you. Right, members, would you like to have about 5 minutes comfort break? Yes? Okay, yeah. So we'll resume in, say, at about, what time? 3 o'clock. 3 o'clock, please. Thank you. It's 3 o'clock. We can make a start. Item 5.3 is 1 Grove Street, Woodstone. Now, I can see that the applicant's here, but he missed his deadline to submit that he is willing to speak at committee. Now, members, would you be in agreement to allow him to speak? Yeah? Okay. All right. Thank you.
No, hang on.
Sorry, you got...
Do excuse me, Chair. I'd just like to point out there are 2 residents here who also missed the deadline. If you're going to allow the applicant, it would seem equality of arms to allow them also to speak. Thank you, Chair.
Right, can I put that to the committee as well? Yeah. That's the whole purpose of the committee, isn't it? We give you an opportunity. Okay, thank you. Right, can I ask the officer to introduce the item then, please? Thank you.
Thank you, Chair. The application site is 1 Grove Street. The proposal is for a change of use from Class B1 light industry to car sales showroom with external alterations. Firstly, to provide a bit of context over the application, the reason a change of use is required is because car sales is under sui generis use. The current use is B1 light industry, which was permitted in 1982 without restrictions. B1 use class now falls under use class E. Now, use class E allows for many different uses, and unless planning restrictions exist, this building, this site can actually currently be utilised for the following uses without consultation with the local authority. These are light industry, shops, post office, cafe and restaurants, banks and building society, estate agency, employment agencies, solicitors, gymnasiums, indoor sports and recreation, but not swimming pools or ice skating, doctors, clinics and health centres, creche, offices, as well as research and development. So this site can currently operate under any of those Class E uses with no restrictions at all. The assessment for this application is whether the proposed use is more harmful than the existing use, which could start at any time without restrictions or planning permission. So we've got the plot here, as outlined in the red line, was permitted for light industry in 1982. The character of the area has changed significantly since permission was given. At the time, this area would have had various other types of industrial uses. This particular plot was originally a factory canteen until the change of use in 1982. Through the years, the industrial businesses have gradually moved out of the area, and the area is now mostly residential with the Woodstone Local Centre nearby. So here we've got the Google image. The application site is currently a vacant site on Grove Street. The building is positioned on the rear part of the site and set back of the road by 28.3 metres. It's a 2-storey flat roof building to the front and a single-storey pitch roof building to the back. There's a large parking area at the front of the site. So we've got the existing and proposed site plan. The existing parking area is being retained and used for a mixture of parking and car display. There'll be 4 sites there's 4 spaces for sales, 2 staff parking spaces, 6 visitor parking spaces, that's 12 in total, and there will be cycle storage as well, which is inside the cover lobby on the side of the building. Okay. We've got the existing and the proposed elevations. So the building largely looks the same. The only changes we've got is new CCTV, which is installed to the front, pointing into the forecourt, And then you've got the loading door, and the window is being removed, and that will turn into bifold doors. Okay. Then this is the existing floor plan. So at the moment, you've got 2 offices at first floor, and then ground floor, you've got a reception area, you've got a service room, you've got office, and then you've got a store area. The proposed floor plan, as you can see, mostly removes most of the bottom areas. So they've removed the reception, removed the server, removed the office, removed the store. The first floor offices are being kept, but the stairs are relocated slightly. Okay. So this is a view looking east towards the site. So note the double yellow lines on the near side of the road. The Grove Street is to the left and Orchard Street is to the right. And this photo is looking west out from the site towards Orchard Street. Note the double yellow lines follow the curves of Orchard Street. Okay. So this is just a photo of the site viewed from the street. And here we've got looking onto the north on Orchard Street. The application site is to the east. You've got double yellow lines on both sides of the road here. And this is a photo looking north on Grove Street from the application site. On the left, you've got access to David Chalmers Close, followed by Tower Street. On the right is access to Symington Close, Orchard Street and Tower Court. To the end of the road is access to the Groves Community Centre. The double yellow lines end here, and there's no parking restrictions on the straight sections of Grove Street. So in terms of assessment, the fallback for this is whether the new use would be more harmful than the existing use. As existing, it's got no restrictions on operating hours and can be used as anything that falls within Class E without planning permission and without restrictions. It's obvious that any use on this site is going to be felt by neighbouring residents as the site is currently vacant. An application for a change of use allows us to control and limit its use. In this case, specifically car sales only, and to control the hours of operation to the day, time, and to ensure that neighbour amenity is preserved. The proposed operating hours for this site is Monday to Saturday, 9:30 till 6, Sundays and bank holidays, 10:30 till 4, which are reasonable daytime hours. Residents have expressed concerns with regards to traffic, car transporters, parking, especially on match days and school run times where the area is particularly busy. Although planning cannot resolve existing highway problems in this area, by condition, we can put controls in place to ensure that no transporters and lowriders are to be used for the stocking or restocking of this site, and that the initial stocking not to take place during peak times or match days. The car park, the restocking must also be done on a one-on-one basis. So when one gets sold, another will be bought in from another site. The car parking for staff, visitors and display cars in the forecourt area to be as per the proposed plan. The site is limited to car sales only, and no other types of motor vehicles can be sold here. And hours of operation are controlled and limited. In conclusion, the proposed change of use would meet the local plan policies. Therefore, the recommendation is approval with conditions.
Thank you. We've got 2 ward councillors, Nick Thorburn and Andy Coles. Ward councillors, to address the committee, you will have up to 10 minutes if you'd like to come forward. Between you in which to address the committee, the Democratic Service Officer will let you know when you have 30 seconds left and when the time has lapsed. When you are ready, if you can please switch on the mic and start speaking. Thank you.
Thank you, Chair. Through you. I'll go first. We'll split it in half. Is that okay? Okay, so Grove Street, the light industrial unit on Grove Street has been there for many years. And that particular part of Woodston is primarily residential. It's part of multiple pinch points in the area, regards traffic flow, pedestrian flow, and there is real concern in the area that the change of use over 7 days will make a significant impact on that. I'm particularly concerned with the flow of school children to and from school, because that area, that S-bend, is a part of the area where you get a lot of flow going backwards and forwards between 8:30, 9:30, etc. So I've got safety concerns around that. The main thing for me is that over many years, the residents and the people running the businesses in that particular site have worked well together to keep them pinch points open and working. And I know personally the previous businesses there were very mindful of their responsibilities towards the local community, because they are smack bang in the middle of a residential area, and they would work and open and do their daily business to help the local residents continue with their daily lives. The opening hours for this will not allow that to happen. There will be significant consequences on people's lives at home, the flow, etc., etc. So I'm concerned about safety and the breaking down of what has become the norm over many years of working together. I have my concerns because of history, recent history in the area. We have had 4 or 5 car showrooms open up, and to put it mildly, they have caused chaos. And they have cost the City Council money, time and effort, and from the history of what we've been through in Wharf Road, Whaley Road, Oundle Road, they say they won't have transporters, they always have transporters. They say they won't do X, Y or Z, and it always happens. To the point it is breaking down. It is on Whaley Road, which I have a personal, I'm there every day because I've got an office there. The showroom there is driving businesses and people away, because you physically cannot do your daily job or live your daily life with a car showroom. The impact is significant. So the point I'm making is history of this. You can put constraints in, they seem to be ignored, and the locals work together to make these things happen, and by allowing this, that's going to break down. We're going to have multiple pinch points, multiple issues. So I urge you to turn this down.
Thank you.
Chair, thank you very much. And I'd also like to put on record my thanks for allowing Heather and Jenny to speak later. They will be able to tell you about the local community concerns and the amount of objections that they've received from residents around there. So 1 Grove Street, as you've heard, and if you look at the photographs, and it's extraordinary to see photographs where there aren't cars and vans parked all the way along, because that's the normal experience. So well done whoever took those photographs for the time you chose, because you've got one of the rare occasions when there isn't complete parking problems there. The issue for me, which I really want to highlight, is the community impact, and why in particular it's around car showrooms and the sale of second-hand cars. If we look at the issues with Wharf Road, JJ Premium Cars, it's mentioned on page 57 of the report. That has been probably the largest postbag for me for 2.5 years, while that particular organisation put stock cars in the road because it was unrestricted and they didn't really care about that. Tested cars, driving them up and down at speed. The local community were absolutely furious about that because there were some very near misses. Luckily, no injuries to children. There was one particular case with the cyclist, but that didn't get to the stage of particular injury. And the level of pressure and irritation in the community is something to bear in mind, that the community are very much unhappy about further developments in this particular area. The community are more than happy for the previous planning application for 6 apartments to go in because it's a residential area. Yes, it has been mixed industrial, but there's so little industrial left now. It's all becoming a residential area, a quiet residential area. There are great concerns that people turn up to this particular premises, look at the vehicles, take them out. If you drive to your left, you go straight into very highly congested areas with a lot of parking either side of the road, very little space, a lot of children around too. If you turn to the right, you see you go down past the community centre, then you're onto Arundel Road. Not so much of an issue on that route, but you are passing junctions down there. And as I say, you don't see from the pictures how congested it is normally. So I've talked about highway safety. I've talked about the impact on the community. There is going to be a new person who arrives here who's going to have a business, and if that business becomes successful, we are hoping that they will apply consistently the conditions, that they won't use a low loader or a transporter. Well, I'm sorry, if you look at what we've seen in Wharf Road, we've seen transporters turning up in the middle of the day, parked in Arundel Road, complete traffic chaos. We've seen it also in Morley Way. You turn up, there are 5 parked up on the road, and either side where there are bays where they should be parking, there's double row of parking of the workers who refuse to park properly elsewhere and abandon the vehicles. So as you can see, there's a huge history here. The local community are very much not keen on this sort of development, change of use from what is a small light industrial, and let's be honest, the only reason this is changing to this particular use is because the developer has decided that this is more economic for them than the previous plan, which was to build residential, moving from a situation where the community would have supported it to one where they are not supporting it. I would therefore ask that the committee consider very carefully those conditions and whether they can be applied in terms of parking and use of transporters and low loaders, and whether that's relevant, because the experience of the local community has been entirely opposite. I think I'll end there just to say, please, I'd ask the committee to oppose this particular change of use for this premises in this specific location. Chair, thank you very much for the time.
Thank you for your presentation. Just a polite reminder to members that if you want to ask any questions to officers or councillors, please go through the chair, and if you have any supplementary, the same principle applies. Any questions? Councillor Hussain.
A couple of questions for the councillors. The other businesses that you mentioned, from my understanding and knowledge of car dealers in Peterborough, they're a lot bigger. This site would potentially hold, from my mind, about 20, but we can ask the applicant how many they intend. The businesses you mentioned, I think, have about 60 to 80 vehicles, so they're probably 4 times as big. Would you agree with that?
No, the one that's causing me personally chaos has 15 vehicles, and it's causing chaos.
If I could add, Councillor, you're right, they are bigger businesses, and of course this business is an offshoot of a much larger business in Fengate. So similar issues here about the number of stock that are available are the same as the bigger ones we mentioned in Wharf Road and also in Morley Way.
Councillor Jamil.
Thank you, Chair. Councillor Thurman, you said that the businesses in the area and the community work well together. What would you say to the fact that how do you know that this new applicant won't be the same?
Just purely on the half a dozen that have moved into the area over the past few years' experience. The car dealership, all the car second-hand showrooms are noisy. They cause a lot of traffic issues, and they have their own interests that come first. So the ones that we have experience of in the past few years all have not been part of the community and not helped in the community. I'll give you an example. A previous occupant of that site, a company called Summit, they was there for many, many years, and they would ensure that deliveries, and when they're open and when they're closed and when they was doing things, were helping the local community. And that is something we have not seen from second-hand car dealerships in the area. They are purely causing chaos and upset.
Councillor Hogg.
Thank you, Chair, and through you. So these other units that are not related in any shape or form, presumably, to this particular applicant, are they just showroom only, or do they do work on the vehicles as well? Do you know?
One does work on the one does work, and the other 3 are showrooms. But there is a car mechanic next door on one of them. So 3 of them, in effect, are just showrooms. The smallest one, which I keep bringing up, is the tiny one. No mechanical work at all going on there, and it's just murder.
And the other question is, these previous occupants of the plot, presumably these were kind of industrial endeavours, and they had HGV vehicles delivering into them, presumably?
No, they never know. Summit, for instance, who were there for many, many years, deliberately went out of their way to ensure that there was no upset, so that their deliveries would come small vehicle, and they would distribute. They actually came up with the process of distributing not from that site to try to mitigate the problems. I was a customer there for many years, so it was actually quite interesting how they actually worked with it, and they had to, because if they had the HGVs turn up, it would have caused chaos. And they went out their way to do it, and the locals do it as well. So everyone's working together, and we've just not seen that with other car dealerships, and that's the concern, is that our experience will be replicated again and again and again. And this one's just one too many. Wrong place, one too many.
Thank you. Councillor Cole, you want to come in?
Just to deal with your first point, Councillor Hogg, you're right to ask that question, yes. When it comes to Big Motoring World and in Wharf Road, they were full preparation places, so there's a lot of work done on the vehicles to make them ready for sale rather than being showrooms, but that's not precisely the issue that we're dealing with here. We recognise it's a showroom. If you would look at another site in Woodston, in Botolph Green, there's a small showroom there. And for years, that was a thorn in the side of previous councillors, where the result was the council had to put yellow lines right the way down Botolph Green to deal with the constant parking of stock and of customers arriving in that area, causing traffic dangers to the residents there. So that's probably a better example than the two large ones that I gave earlier, but that was about transporters.
Thank you. Councillor Sharp.
Thank you, Chair, for you. Yes, you've understandably made some comments, councillors, in relation to the amenity impact. But I do know on page 57 the officers' comments where they state the proposed use would not be significantly different to the existing light industrial use in terms of intensity impacts. And I appreciate it's not being used, but the current status. Are you saying then, based on your comments around amenity, you disagree with that officer's view? And if so, can you summarise the specifics? Thank you.
Yeah, I disagree with the view. Yeah, it's vehicle consumer sales. Every other business in there was B2B sales, so it made a light impact on the community. When you've got the constant flowing of vehicles, parking issues, and inevitably low loaders coming down a very small Victorian area, it will have a significant impact. So yes, I do disagree fully with that.
And thank you, Chair. If I could add, what we're looking at here is the second-hand vehicle market, and what we've seen over the last years is significant growth. And then what's happened as a result is that the roads have been filled with cars for sale, stock cars, and much more activity than one would have expected. So in this particular case, I'd have to say we have to look at the particular trade we're talking about here and the impact on the community. And I think that's, my view differs from that within the report with this specific trade in the area of Woodston. Thank you, Chair.
Councillor Hussain.
Thank you, Chair. There's been a lot said about car transporters, but in the report, officers have said we would have more control. The applicant, from what I've read in here, has also agreed with officers that there won't be car transporters. I know you've said other businesses in the area do that and they carry on with car transporters. But saying by this, if officers have got more control, surely we can then manage and make sure that that's not happening. Would you agree with that, firstly? Secondly, another part of the question is, at the moment, it's for light industrial use. Light industrial use can also include, tyre changing shops, MOT workshops, car garages. Sorry.
Question.
Yeah.
That's more a question to the officers, isn't it?
No, I was going to ask whether it would. So basically, whether councillors would agree with me that a business like that, where it's car, say, workshop or an MOT station, will have a lot more traffic, low loaders for car repairs coming in, rather than a business that's just specifically for car retail. Would that not impact the neighbours more when you think about the air tools, etc., during the day? rather than vehicles that are just stationary?
Thank you, Chair, sorry. I would actually say no. From my experience recently with car showrooms in the past few years, the impact they've had is far greater. So Wharf Road, for instance, there was a mechanics down Wharf Road for many, many years. And there still is. There's still a couple down that way. But the car showrooms moved in, and the utter pandemonium that ensued was tenfold of that. So, yeah, you're right, you can have pneumatic air pressure kit running down there, but take my word for it, in Woodston, the impact would be less than the car showroom, significantly less.
Councillor Coles.
Thank you, Chair. If I could come back to your first question about the conditions that are in place that would control that. Well, yes, you have conditions, and then you have the ability to enforce those conditions. We have not seen adequate enforcement in all the other locations from the council or from police. It's just a matter of fact. So while we have the capacity for it in terms of, yes, we have enforcement staff who could do it, the actual delivery of the enforcement is highly unlikely. And that's one of the big complaints I receive from residents, is that well, it's all very well you put these conditions in, but you're not going to be in a position to be able physically to deal with them. And the examples of all the other cases we've had is of this particular trade is that you do get these issues that develop anyway, never mind the fact you have conditions at planning stage. Thank you, Chair.
Thank you. I have a question. Thank you for your address. I think you covered most of the points, but there's one point that I would like your opinion on. The site already has a B1 use which falls under Class E. And in the officer's report, if I'm right, they don't need any planning permission. They can open a shop, off-license shop, solicitor's office, anything like that, and there's no control over the vehicles. Surely this application gives control to the council. So would you not agree with that?
Again, from experience in the area, no, I wouldn't agree with that. The volume and the exceptions to what. Give you an example. Down George Street, there's 4 cars that haven't come up to scratch that have been left down there, and it's a Victorian street, and there's no way of us actually doing anything about that. It just goes on and on and on. So no, I would rather have a solicitors there any day.
Thank you. Any further questions?
Do you want me to respond?
Oh, you'll respond? Okay, please do.
I think I'd agree with Nick on this, and Councillor Thorburn is quite right that there could be a different use. You're quite right. However, of course, and the light industrial allows that sort of thing, but that is not what the residents are worried about. It's not what the community have been most affected by, and that is about the trade in motor vehicles and its impact on the streets, which they know and they've seen, and they know how much of a nuisance it is. So I think there might be other industries that could be use that premises, but we're dealing with the planning application for motor vehicle showroom and ancillary uses that will bring. Thank you.
Thank you. Any further questions? No? In that case, would you like to take a seat back in the gallery? And we have 2 objectors. Would you like to take a seat? Yes, please do. It's got 5 minutes in between them, isn't it? Okay. Thank you. You will have 5 minutes between you in which to address the committee. The Democratic Service Officer will let you know when you have 30 seconds left and when the time has lapsed. When you're ready, if you can please switch on your mic and start speaking. Thank you.
I'd like to say that I really very strongly object to the point about having not just a commercial business, because we've had one there and they have been very quiet. It's the issue that this is going to be a car sales room. There is going to be traffic to and fro down that very small road all the time, weekends and during the day. The noise and disturbance that the weekend trading is going to cause is going to be very, very hard on the community. It's a quiet residential areas. I can sit in my garden and I can hear the birds. I don't hear the traffic. I can hear the football ground now and again, but I can't really hear traffic, or I can't hear people revving engines and doing that kind of thing. Sorry. Right, so the thing that I'm more worried about is the traffic, the congestion, the possibility, or should I say the probability, of customers parking off-site, road testing vehicles around an area. I live on David Chalmers Close. I come from the top of my road onto Grove Street. I have a corner on one direction, and when traffic is parked going down Grove Street towards Tower Street, the road is blocked. I have to go into the middle of the road to see what's coming down the road. My vision is totally blocked. I know that Highways have made an objection regarding the low loaders and the moving in and out of sight of vehicles. It's not going to be just once a week. It's going to be many times a week. It's probably going to be many times a day. The increase of traffic and the delivery vehicles, it's not going to be policed. It's not going to be policed. It just can't be done. And such companies aren't sort of like complying with what's actually happening with the planning. So there's only meant to be 16 cars on site. That's really not viable if you're running a business for saying we're having 16 cars on site. Happens when they sell 5 cars. The 5 cars will be brought in, they'll be brought out, they're test driven, which probably will go on all day, weekends, Saturdays and Sundays.
Can I just interrupt? We've got 2 minutes left. Would you want to give her an opportunity to speak?
You want to go?
Unless you've got anything.
Go
on. Thank you for...
Mike on. Thank you.
Thank you for letting us speak. We did slightly miss the deadline, so that is appreciated. Number of reasons I'm objecting as a local resident, and there is, I believe I represent a lot of other people as well, is number one is the increase in traffic. The street was designed as a Victorian road. It has 2 blind bends. The road is unsuitable and totally inappropriate for this type of business. These roads are not designed to allow for the turning of low loaders or any other large vehicle. This view is supported by the Highways Authority, hence the no loaders proposed condition. But the agency does actually go on to state, in their experience, they're the professionals, that this does not seem to deter the use of low loaders with this type of planning application. So as far as I'm concerned, you know, they are the authority on that aspect. It's also not clear who would enforce any breach, whether it's the police or council. But as has been said, regardless, it's not believed any enforcement action would be taken due to resources, financial and staffing, and conflicting priorities. There's also a precedent, as you've heard, with a similar type of operation close by in Wharf Road, which has caused major problems for local residents, including traffic violations. There have been numerous complaints from local residents who do not feel these areas are being addressed adequately or sufficiently, despite the support from local councillors. So
30 seconds left.
We need to nip this in the bud. This is also a 7-day-a-week operation. We currently have no businesses, whatever, even a local shop, that operate in those 2 streets 7 days a week. Pollution, obviously my time is up. This would have a negative impact on our quality of lives and our local amenities. Thank you.
Thank you for your presentation. Members, do you have any questions? I have a question. Now, are you aware that the site already has a B1 use, which is classed as E, where if the applicant wants to open anything, the council will have no control over the traffic, the increased traffic. By this application, what the officers have said in their report, that they could control, impose conditions. So would you still maintain your position?
Historically, I didn't know what class it was, but I knew it was light industry. Historically, the light industry that has been there has been 5 days a week. It's been quiet. It hasn't actually had any real impact. I think changing the use also opens up opportunities for the future that could be even more detrimental. Personally, I appreciate the point you're making, but I don't actually think that is relevant to this application. Thank you.
Any further questions? No? In that case, if you'd like to take a seat at the back. If I could ask the applicant, if you could make your way. I don't know his name. I don't know what his name is. Thank you. Take a seat. You have up to 5 minutes in which to address the committee. The Democratic Service Officer will let you know when you have 3 seconds left and when the time has lapsed. When you're ready, if you can please switch on your mic and start speaking. Or you already got that. Thank you.
Thank you, Chairman. Just to let's say one thing is, obviously, we've got a site in Fengate that does all, obviously, the deliveries, prep, getting all the cars ready in Fengate. That's 2 miles away from Ander Road. These cars that will be coming there, they'll be driven down one by one, parked up, and then customers will be turning up on site, indoor, having a look at the cars from there, and then just driving away with them from there, from the showroom. There'll be no transporters on site, and we'll just be working on time. We don't want to upset the neighbours, but we've had a number of companies that want to turn up and obviously take this place on rent and have it open from morning till night, i.e. as a gym. But we've obviously said that we want to obviously expand our own business. With the stock that we do is obviously like, we do the price range stuff that sells every day, but then we want to do the more high-end stuff, and them customers don't come in every day. So it might be 1 or 2 customers coming in a week. We've got car park spaces at the front of the pitch, and yeah, there's an ample amount of space there for them to park. So nobody will be parking on the road, and test drives will normally be a staff member will be going out with the customer on a test drive. So there won't be no revvings on engines, no speeding. Yeah, apart from that, there's not much else I could sit there and say here.
Thank you. If you could just switch your mic off now, please. Thank you. Right, members, any questions yet? Councillor Harper.
Yes, thank you, Chair, and through you. Just clarification, if you could please. It says in the report that viewing, test driving, etc., will be by appointment only. So are you effectively saying that people can't just turn up and have a look around?
All the cars we advertise online, so it'd be like obviously a customer will call, make appointment, and obviously we'll make sure we've got the car ready for the customer, out ready, and then they'll turn up and then they'll go out for a test drive with us.
Thank you. Any further questions? Councillor Jamil?
Yeah, one of the things that's come out from the previous speakers is the real community feel for that area, which I'm sure when you were sitting at the back that you picked up as well. What are you willing to do to work with the residents, if anything, in order to alleviate some of their fears?
I understand that. Obviously, I've seen one of the neighbours that are here. I don't want to mess around with my neighbours. I do business on a daily basis. Get me where you live, your neighbours are like your family, and I don't want to upset anybody on the road. But if I wanted to give the business out to somebody that was obviously going to cause a lot of noise, it won't be in my hands. I just want to expand my own business, obviously, and just take the next step forward.
Thank you. Councillor Hogg?
Yeah, I just wanted to ask you, through you, Chair, how many visitors a day to the site are you anticipating, based presumably on your current business?
Well, we hold about 120 cars on site in Fengate, and with the climate right now, there might be 4 to 5 customers a week. That's because of the volume of cars. But if you're holding about 15 cars, and they're obviously the upmarket cars, then you might be getting 2 or max to 3 customers a week.
So, so how are you splitting your stock between the two? Is it just going to be a kind of a straight split, or
No.
are you
You're
looking to do a different?
The stock that's staying on in Fengate will be the same stock.
Yeah.
This will just be buying new stock for the new site.
the same what you currently do is or are
Not
you
the
looking
same
for
stock that
a
we
different
got,
niche?
But the different niche market, yeah. So like prestige stock.
Okay, thank you.
Thank you. Any further questions? Thank you. Thank you. You can take a seat at the back. Now, any questions for officers? Councillor Hogg?
Thank you, Chair, and through you. I just wanted to ask what are our teeth in regards to these conditions? Do we have been some legitimate concerns raised about transporters turning up even though they're not allowed? What is the likelihood of us being able to do something about that? There's also talk of overspilled stock being parked in the streets around the area. Again, is there some sort of condition that can be placed, and can that be enforced? So I'd just like to know a little bit about that, basically.
Okay, in regards to the conditions, so the transporters, obviously, like we said, we can condition that not to be used, and we've agreed that not to be used. We have checked it with enforcement, and it does meet the 6 tests, so it is enforceable. In terms of the overspill in stock, again, we've conditioned that they must be in that forecourt only, that it must be as per the layout, as per that forecourt layout. So that would refrain from them parking outside of the area.
Do you want me to come in as well?
Yeah.
Okay, you want to come in?
Yeah, through you, Chairman. Just to clarify a point on the other car sales premises in the district, the one at, is it Worley Road or Worley Street? I've just checked that one, and that was granted planning permission many years ago. There was no conditions on there restricting low loaders or transporters or anything like that. So the conditions that we are suggesting on this current application are far stronger than any of those that were imposed on those historic permissions. Yeah, as Karen rightly said, we've consulted with our enforcement colleagues. They've confirmed that these conditions do fit the test. They are enforceable. Due to the sort of kind of low-key nature of this as a car sales only, we're on a relatively small scale, we're confident that, or we don't have any reason to believe that, there's a high probability of conditions being broken, but if they were, then obviously we can take enforcement action if necessary.
Thank you for that clarification. Councillor Jamil?
Thank you, Chair. Phil's actually answered the question I was going to ask around, do we have similar conditions with the other car yards that are in the area? And then if we can't enforce those, then how would we be able to enforce these? Just out of interest, yeah, if these conditions were then broken by the applicant, what would the process be? How would we then go forward?
So what tends to happen is if it comes to our attention, usually via members of the public, that a condition has been breached, we then set up an enforcement case. Our enforcement officers will then investigate, and they have to make a judgment as to what to do next. Sometimes it's not expedient to take any action, but often it is. And in those cases, there's a number of steps that our enforcement people can go through. They don't immediately serve an enforcement or a stop notice. Normally, they will have a conversation with the person who's allegedly making a breach, try and bring an end to it without having to serve an enforcement notice. If that doesn't work, then there's all these other courses of action that they can take, serving an enforcement notice, a stop notice if necessary, and it can ultimately go to court if there's a continued breach, and then a breach of an enforcement notice. That becomes a criminal offence then. So there's lots of things our enforcement people can do.
Thank you. Councillor Fitzgerald?
Thank you. There's been a lot of talk earlier in the discussions, particularly with councillors, about what other garages do. And I think that's wrong. You mustn't associate what other people do with this application. This application is with the bad behaviour of others, particularly if they are not operating on the same grounds. What I was going to suggest, Chair, and it might be, because we're following on from Phil's comments there, can it be a temporary permission? Because if there are concerns about breaches in planning conditions or conditions within the in the application before us, the applicant could be given a period, and it's perfectly normal to get a temporary permission, a temporary change of use, with a view to making it permanent, if the applicant had proven themselves on that site not to be in breach of conditions. I'm asking that, is it technically possible as a condition to add a condition within the existing ones that makes it temporary? That's my question, Chair. Sorry.
Would you like to respond to that?
A temporary permission, a condition restricting it to a temporary period of time, is something that's open to us. However, in this case, the committee needs to be mindful of the fallback position here of what can be done anyway without any further planning permission. So therefore you have to ask yourself, does it fit all the tests of conditions? Is it necessary when there's all these other uses that can go on lawfully? Anyway, if it was you know, a site that hadn't been used for any kind of industrial commercial use previously, and you wanted to assess the impact because there was doubts about it, then that, I think it would be justified in that case. But my advice would be, I don't think a temporary permission would be necessary in this case.
Thank you, thank you. Councillor Sharp?
Thank you, Chair. Yeah, on a similar vein, it just probably perhaps a question for legal, or certainly for Karen, in terms of clarity on these conditions, because there's been debate about whether we will enforce them as a council. Obviously, Phil and Karen have clarified that they meet the criteria for enforcement. So my question is it a consideration for us whether the council does or doesn't enforce them as long as they're enforceable? That's my question.
Thank you.
Yes, Councillor, enforcement is discretionary. Our enforcement team have to make a call as to whether it's expedient in the public interest or not to take any enforcement action. And in the case of these conditions that we're suggesting here, I would suggest any breach of those is likely to be something that our officers would want to take any necessary action to remedy.
Thank you. Any further questions? Right, if there are no further questions, can we move to the debate? Councillor Fitzgerald.
Okay, well, thank you, Chair.
I missed your hand.
So I'll return to where I left off. The problem is you've got a lot of concerned residents, concerned councillors, and there's no cumulative impact policy, as far as I'm aware, on garages anywhere in the city. We have them for other things. And as I said, you can't hold the applicant responsible or accountable for what happens elsewhere. So I will be recommending, from me, I hope I get support, because the applicant can prove his case over a 3-year period. And it would be in his interest not to break those conditions, because if it came back to this committee for full approval, the likelihood of you getting it, if you broke those conditions over that period of time, is probably 0. The fact also, if we talk about enforcement, we are stretched as a council on resources. We have every intention of enforcing, but frustratingly in planning, it's not what we, the committee or councillors, would expect. But I will big up our parking enforcement services. I reported something in Wayneman Road in the same patch, and they took action on it. So if there's enough noise about it, they will. But often with planning, if it ended up, Phil, with a revocation of the planning permission, if you went that far, fine, that's the legal remedy. But a temporary permission gives the public confidence, because you're right, it could be many, many other things. It gives the public confidence that actually it wouldn't be forever, and you have to come back having proven your case. So I'll make that recommendation, Chair, whether it's now or at some point during the debate.
Thank you. Councillor Hogg.
Thank you, Chair. So I can draw on my own experience on this, in the fact that I've got an industrial unit in the city, and 2 doors down is a unit that has it's a car showroom, high-end cars, much bigger than this in terms of floor space and the number of cars that they have for sale. And I'm very surprised about how little sort of coming and going there is actually in terms of people coming to view the vehicles and drive them around. And I certainly don't have my experience from that car showroom is that, you know, it is a very low impact business in terms of the industrial estate that I have my unit on. In fact, next door to them, fairly briefly, maybe 6 months, something like that, a camper van conversion company moved in, and it was chaos. It was absolute chaos. Literally, dozens of camper vans in various states of construction, you know, with windows missing and pop tops on, but you know, this, that, and the other, and they literally just abandoned them on the corner, blocking footpaths, all sorts of things. It was a complete nightmare. Thankfully for us and our neighbours, that the company seems to have gone into liquidation and that the problem has now gone away. So I am very mindful of the fact that you know, where how quickly the situation can change depending on who actually turns up and starts using that unit. So and you know, within the square that my unit is in, I've been there since 2014, so it's a number of years, and I've seen people come and go, and in the main B1 units are relatively low impact, but there are a notable number that are clearly not. So it's a question of, you know, be careful what you wish for. That, you know, if this application was turned down, it may well be that tomorrow somebody that was to turn up that wasn't really responsive to the needs of the neighbourhood, and you know, just wanted to go about their business. It could be, you know, the camper van conversion company or something like that. That could be an absolute nightmare for the residents. I think in the round, the fact that this application is one of, you know, it's not a huge showroom for the number of cars that they're going to be able to have there. So I'm convinced that there's not going to be a huge amount of comings and goings to the site. They've got a site elsewhere where they do the preparation work. So there's absolutely no reason for low loaders to turn up to site, because they're going to be going to the other site for the preparation works to happen. So I think, you know, with the conditions, there's a lot of conditions here, and I think, I'd like to think that our enforcement teams are able to deal with any mischief that happens. And, you know, as Councillor Fitzgerald said, ultimately, you know, we can't tar this application with the brush of other organisations that may not be doing things in the correct way. So I'm minded to approve or go along with officers' recommendation.
Thank you, Councillor Hogg. Councillor Hussain.
Thank you, Chair. Just a couple of things to pick up on. Basically, yes, I've had experience in the car trade for the last 30 odd years. As Councillor Hogg says, I don't think it's fair to tar every car dealer with the same brush, although some of them probably do need tarring. But that said, you know, this is, from my experience, it's a small site. There was concern about parking on the road. There's yellow lines up and down across, you know, from the pictures that we've seen. Used cars nowadays, when a car's sold and it's put into the trade, the road tax is cancelled. So if anyone parks a car on the road and it's within the trade, then it's untaxed, and that can be obviously, they can be penalised for it. Firstly, low loaders have already said, and I don't think this company, for the size of vehicles, for the size of the forecourt, would need low loaders. Not only because of the cost of getting those low loaders to deliver those vehicles, it's cheaper just to get one car there delivered by a driver on plates. So yeah, the other thing I think I would touch on is the fact that it can at the moment be used for other light industry. As Councillor Hogg said, there's nothing to stop a garage, MOT station, someone else, a paint shop, car paint shop coming in there as light industry. The vehicle movement from those businesses or a shop would be a lot more than you would see from a car dealership, where they probably, at most, for the number of cars they would have, I would expect them to have maybe 2 customers at the day on the best days. So, that's 4 to 10 maximum car movements a day, whereas if it was retail or a workshop, you're talking, 10, 20 times that. Thank you.
Thank you, Councillor Hussain. Councillor Warren?
Thank you, Chair. And I just want to start, obviously, with the opening segment that it was. Is this going to be more harmful than the current permitted use that we've got? And I was looking at that, and what evidence can we have to say that it is going to be more harmful? If you was listening to the councillors, you would say so, because they were looking at the old businesses that they've got with them, and that all the old car salesman people are creating a lot of harm. And we can all sympathise with those councillors, because we've all probably got similar businesses, similar people that are creating that harm. But when you dive down deeper, those current businesses don't have the conditions in place that will actually prevent the harm that's going to cause. And with those conditions, especially with C3 and C4 conditions, that will probably make sure that the cumulative impact on that area will not actually be what we have with the current use. And it will actually mean that we have probably the same harm if we had some kind of shop or car place or anything else in that place. So, and with obviously with the statement that we had from the applicant, he's running a business, got prestige cars, limited impact, limited neighbours and limited what he has. So with the opening thing, will this have more harm? I would say it would not have more harm than the current permitted use. So I will go with the officer's recommendation and grant this application.
Thank you, Councillor Warren. Anybody else who would like to? Councillor Jones?
Thank you, Chair. Excuse me, and through you. It was mentioned in the previous application many moons ago, just because you don't like it doesn't mean you shouldn't approve it. It's a light industrial setting in a residential area. So it's not a great fit, but I think it was, whoever it was said, just be careful what you wish for. I'm also, I think what we have to do here is, on balance, this revolves entirely around enforcement, and I would hope that the applicant is mindful of the area. It is an industrial unit in a residential area, so whilst it's not a great fit, then I'm minded to go with officer recommendations on balance, rather than, it's one of those hearts and heads again.
Anybody else would like to contribute to the debate? Are you going to bring your proposal now, Councillor Jarrett, or?
Well, Chair, if I may,
I just wanted to say something.
Oh, well, by all means, I was just going to say, if there is support for it, fine. My rationale for thinking, even though I understood what Phil said, Chair, is that it allays the fears of local residents and local councillors if we did it on a temporary basis, with a view to making it permanent. But if there's no support from members of the committee, I'm not going to push it. But I just think it helps those people that were against it, because I will be voting for it, but I'm trying to put in a safeguard for councillors and residents to allay their fears, which have transferred from other operators, that this won't be the case with the new applicant. Sorry, Chair. But if there's no support, I won't do it.
Thank you, thank you. Councillor Hopper, did you want to come in?
Yes, thank you, Chair, and through you. Is the proposal more harmful than the current available uses? Well, I think we've heard that what could happen, particularly something like a shop, is probably the worst scenario for me, or a paint shop, and the amount of visits and the amount of noise. I think to refuse this on whether or not our enforcement team are effective would be extremely dodgy water to tread, and you know, we need to put more into that if that's the case. And I have no doubt that the three councillors that have been extremely against this will be enforcing in their own right and making sure that enforcement are taking the appropriate action if this happens. And I'm sure I could tell the applicant that, you know, make no bones about this, you will be being watched now by your local people, local residents and your ward councillors. So putting it off, Councillor Fitzgerald makes a good point about a temporary permission, but doing that for me just drives home the fact that we probably then are not going to enforce it for 2 or 3 years. So I think, just personally from my point of view, I think it's not going to be worse than what could happen. I totally understand the test driving, you know, they're saying there's not so much traffic, test drives will be controlled, well, yeah, in the best will in the world. Parking will be controlled, yeah, it's all in there, it's all in the conditions. The conditions are fine, they're good, I think they've tucked everything up nicely. So I will be supporting the application, but I wouldn't support this to go to a temporary permission. Thank you.
Thank you. Councillor Jamil.
Thank you, Chair. Same as Councillor Harper here. I just think that, you know, there are measures in force that we can use. So I don't feel that having a temporary 3-year, you know, time limit on this would serve much purpose. But I think the fact there's so much interest in the fact that the councillors are, you know, have been quite so active in pursuing this for their residents, and if anything went wrong, they'd be on the back of enforcement. So therefore, I will hope that we can get this through without actually going for a temporary period. So I will be supporting it.
Thank you. Any more? Sorry. Go on. You would like to make a point of clarification? Please do.
Yeah, thank you, Chair. Through you. So I think it was mentioned that, well, we mentioned the fallback position of all the different uses that this site could be used for now without need for any further planning permission. I think, I can't remember which councillor it was, but somebody mentioned the fallback use included paint shops or repair shops or MOT stations. Just to clarify, that isn't the case. The current use doesn't authorise those. They are B2 general industry, which would need a separate permission, which would be unlikely to be granted in a residential area. So either under the current authorised use, that couldn't happen, and if members were to grant this use, it couldn't revert to any of those more intensive car-related uses. That would need a separate permission.
Thank you for the clarification. Councillor Hopper.
Yeah, Chairs, that being the case, and we did have a comprehensive list read out earlier, could we have that list again so as we can, you know, because my view is it still could be a shop. It could be, well, almost anything effectively, and people could come and go as they like. Not to knock the co-op, but to say it was a co-op store or a VG or whatever they're called now. People could come and go all day. Am I right on that one?
I think you raised a good point. Yeah, if you would like to read out the list, please.
Okay. So the list of uses under Class E is light industrial in residential area, shops, post offices, cafes and restaurants, banks and building societies, estate agencies, employment agencies, solicitors, gymnasium, indoor sports and recreation, but not swimming pools or ice skating, doctors, clinics and health centres, creche, offices, and research and development.
Thank you.
Yeah, it doesn't change my mind. I'm still of the opinion that
yeah, I think that's a very
it's no worse
list.
than what could happen.
Thank you. I think we've had a good debate on it. I'd just like to say about the temporary permit. I've been a councillor and sitting on the planning committee for some time. From my experience, we've always had an option of temporary permits on a venture which is a new venture, where we are not satisfied, and officers are about 50-50 on it. You know, they're not very keen whether we should do it or not, and it just comes as a recommendation from officers that I think a temporary permit would be good, so we could assess the behaviour of the applicant. In this case, I think it doesn't meet that merit. So I'm totally against the idea of temporary permit. If you're going to agree, we're going to agree with the officer's recommendation. The debate I've heard, I'm minded to go with the officer's recommendation on the basis that the list has been read out, and I think it would cause more harm if we had those, that list, any of those lists opening there. It'd have less harm with the current operational system in place. So if there's no further debate on this, we could probably now go for a proposal. Now, who would like to propose? Councillor Hussain.
I'd like to propose that we go with the officer's recommendation, sorry.
Councillor Jamil.
I second that proposal, Chair.
Okay, right. All those in favour, raise your green.
Yes, unanimous.
Unanimous. Any against? Abstentions? Karen, would you like to read out the result, please?
Thank you, Chair. That is 10 in favour, so unanimous to go with officer's recommendation.
Thank you. Right, we are on agenda 5.4. And if I could ask the relevant case officer to introduce the item, please.
Thank you, Chair. The application site is number 43 Viney Close. The proposal is a change of use from single dwelling house, use class C3, to residential care home, use class C2, for children with special educational needs and disabilities, learning difficulties, emotional and behavioural difficulties, and associated alterations. Firstly, to provide a bit of context over the application, the company applying is called The Beaches. The proposed age range for this children's home is 8 to 18. They have advised that 8 to 18 is largely for registration purposes and that the occupants are likely to be 16 and 17-year-olds. The children's home would have a maximum of 2 children living there, supported by staff on a 24/7 basis. They expect that young people in the home will be supported on a 2-to-1 or a 1-to-1 basis, likely to only be 1 occupant at the beginning. In terms of the process, in order to open a children's home, first they need to obtain planning permission, and then the next step is to register with Ofsted. The Ofsted stage is when they will go through detailed checks and assessments to ensure that the home and the care offered meets legislation and regulations. The legal requirements that they need to satisfy include Care Standards Act 2000, the Care Act Standard Regulations 2010, and the Children's Home Regulations 2015. With regard to the placement of the children, this is covered by Children's Commissioning. They will have an understanding of the children's care plans and place the children in appropriate homes where their needs could be met. For this application, we're looking at the change of use from C3 residential to C2 residential care home. This is the location of where the home would be. Government guidelines on children's homes says that they should be in domestic environments rather than institutional. The location should support children's safety, well-being and personal development. In addition, the home should meet the needs of the children and they're expected to live there and be located in a neighbourhood where the children can flourish, have access to education, faith, cultural and healthcare services. And the location should also have transport links. So, as you can see from the location plan, the application site is a semi-detached dwelling located on Viney Close within a residential cul-de-sac. The plot has off-road parking spaces to the front and an enclosed rear garden. In addition, there is on-street parking with no parking restrictions. The immediate area is predominantly residential, mostly semi-detached dwelling of the same era around the 1950s. Nearby facilities include a variety of shops at Hill Close, open spaces at Broad Close and Reeves Way, 2 primary schools, we've got Newark Hill and St Thomas More, 2 secondary schools, you've got City of Peterborough Academy and St John Fisher, Viney Close is accessed off Reeves Way, which is on a bus route, and there are several bus stops located close to the application within walking distance. So we've got the proposed block plan. As you can see here, there's very little external changes to the site. The only external change you'll find is that there's a new fence between 43 and 45, as there isn't currently a fence there, and only the side doors of the dwelling is being blocked up. So on this proposed elevation, you can see where the side door is being blocked up, which is these two. Other than that, the dwelling looks the same as existing. The existing floor plan, this is a 2-bedroom dwelling. You've got the ground floor that's located, you've got kitchen, lounge and storage. First floor is 2 bedrooms, a separate toilet and a bathroom. The proposed floor plan, the kitchen is moved to the back. The staff room and the staff office, room with shower is where the kitchen was. And in first floor, it's staying as 2 bedrooms, but the bathroom's going to be removed, and instead you've got new shower added so that both bedrooms will have ensuite shower. Okay. So this is a photo of Viney Close. Viney Close is accessed from Reeves Way. Viney Close is in a T shape, where one end of it goes into the woodlands at the rear of Viney Close. The application site is on the spine section of the T. The application site on this is the second house that's on the left. Parking on this street is a mixture of off-street parking and on-street parking, and there's no highway restriction on here. There's no yellow lines here. So it's just a photo of the front elevation. A photo of the rear elevation. And just a satellite image for you of where it is. So in terms of assessment, the policies that we're assessing this against is LP8, LP13, LP16 and LP17. LP8 is meeting housing needs, that the site is suitable for intended occupiers, which is a maximum of 2 children. The site is close to public transport, schools and local centre. The identified need is supported by Children's Commissioning, and Children's Commission has advised no concerns in regards to the proposal. With regards to LP16, the design, the external changes would not negatively impact the character or appearance of the site or the surrounding area. And as per government guidance on children's home, the location would support children's safety, well-being and personal development with the appropriate schools and facilities nearby. LP17 is for neighbour amenities. As per government guidance, children's homes should be a homely, domestic environment rather than institutional. As such, the children's home would operate in a similar way day to day like a family dwelling would. The noise generated should not be much different from a typical household of 2 adults and 2 children. The home would be staffed 24 hours a day, so any noise that occurs shouldn't be excessive and would be managed by the staff. Well, LP17, which is for the parking, there is sufficient parking to the front with 2 off-street parking spaces. There are on-street parking spaces available with no highway restrictions. The comings and goings would be similar to a residential dwelling, and the most noticeable times would be at staff changeover, which is at 7 a.m. and 10 p.m. In addition, the written ministerial statement on the 23rd of May 2023 from the Minister of State for Housing and Planning, Rachel McLean, MP at the time, states that planning system should not be a barrier to providing homes to the most vulnerable children in society. It notes that local planning authorities should give due weight and be supportive of applications where appropriate, and for all types of accommodation for looked after children in the area to reflect local needs, and all parties in the development process should work together closely to facilitate the timely delivery of such vital accommodation for children across the country. It goes on to state that government expects local planning authorities to support these vital developments where appropriate to ensure that children in need of accommodation are provided for in their communities. and this is a material consideration. In conclusion, the proposed change of use would meet the local plan policies, and therefore recommendation is approval with conditions.
Thank you for your presentation. We have one ward councillor registered to speak on this item, and that is Councillor Jackie Allen. You will have up to 10 minutes in which you need to address the committee. The Democratic Services Officer will let you know when you have 30 seconds left and when the time has lapsed. When you're ready, if you can please switch on your mic and start speaking. Thank you.
Thank you for allowing me to speak. I believe there was some confusion and I appreciate that I've been allowed. The planning application was validated on the 10th of October and appeared on the planning register the 16th of October. Information was sketchy, so I emailed planning officer on the 16th requesting additional information. I received a reply on the 17th of October advising the application was for a residential children's home for two children between the ages of 8 and 18, with a maximum of 2 shifts being 7 to 10 o'clock in the evening and 10 o'clock till 7 a.m. Children would be chaperoned to their schools in the event that any child with very special needs to the local authority would be transported to and from school. I copied Children's Services into my response to see if they'd been consulted in relation to the need for the location and provision and size of property. I was concerned. Proposed age group and safeguarding, staffing arrangements and operational dynamics left me to consider that LP 17 would adversely affect both the future occupiers, the children, and the local community. Children's Services copied commissioning to ask what engagement had taken place with the provider. I had to make a call-in request on the 5th of November in the absence of any feedback from commissioning that could substantiate the need for this home. I concede there may have been sickness in the department at the time. On the 15th of November, after chasing a response, I received an email from commissioning to say they were engaging with the provider on Friday, the 17th of November. If I can just read out some of the responses. So planning precipitated this response from commissioning to say the applicants have now been in touch with you and you're in the process of further talks with them. You have confirmed that there is a need for a children's home in Peterborough. However, you would have a concern that it would remove residential provision. Commissioning came back and says, yes, I do have this meeting. At this point, I haven't confirmed to PCC, haven't confirmed with them that PCC have a general need for this type of provision currently and that the future need is harder to forecast. I will discuss and come back on Friday. When they did come back on Friday, they confirmed that the age range would be 8 to 18, largely for registration purposes. There's a lot of likelies that came in the presentation from planning here. I think we have to consider the application is for 8 to 18-year-old. They also said they were anticipating that the home would be supporting older children, possibly a step down from T4 provision. T4 means that they have had inpatient service for adolescent and children's mental health issues. We did a site visit, and if we look at the plans, the revised plans, there is going to be some of the existing residential space, lounge area, taken up for a corridor to make the allowance for the staff accommodation. The staff accommodation needed in this quite small 2-bed semi is significant and does impact the amenities of the occupiers of this home. I failed to see how a decent two-seater sofas and dining table will actually fit into this space. Also, if we look at the corridor, we don't even know. I doubt that it can be adapted for wheelchair access. There's no downstairs toilet available for visitors unless the staff facilities are made available. But even then, I'm not sure that the children, we're saying they are likely to be children with additional needs and or disabilities. How can they access the downstairs facilities? I would ask, I tried to get engagement for at least 5 weeks before the final responses came through. If we go back to the planning portal, it's not till well after, maybe the 28th or 29th of November, when Children's Commissioning finally say there is a need for this home. Before we submitted this plan to the portal, these conversations should have taken place. There would have been adequate time to discuss. There is space on this site to have an extension if necessary. The parking, if we go back to the residents that have, many residents have lodged their own concerns. I mean, I'm looking at this purely from a corporate parent, if I'm honest, but the residents rightly say that their peace will be disturbed with the shift changes. If the children are at school, they might be on a part-time table. There will be many movements in this particular home that in a cul-de-sac will be noticeable.
Thank you, Councillor, for your presentation. Members, do you have any questions? Councillor Sharp, thank you.
Thank you, Chair. Yes, thanks, Councillor. So if I'm understanding correctly, in relation to the plan that's up on the screen, you're saying that this is just not practical and not acceptable layout for, and if so, what feedback did you get from officers in terms of their view on whether this is a practical and acceptable layout for its use?
I believe Children's Services would not advocate for this had they been engaged from the beginning. Commissioning would have actually gone on record as saying there is a need, but what we've got here is a very limited need in terms of its accessibility. Surely, if we say there is a need for children with additional needs and requirements, we need to make the space fit for purpose, and as it stands, I feel it's not fit for purpose.
Councillor Hussain.
Thank you, Chair. Within the report on page 70, it mentions Children Commissioning had a meeting, with the provider. Do you know by any chance, or maybe if officers can tell us later on, whether they actually went to see the property as well? Or was it just a meeting?
Is that a question to Councillor
A question
Allen?
just
Is
to
it
know-
officer's question at a later stage?
I don't know if Councillor
Will you be
Allen
able to
knows
respond to that?
if there was a meeting and whether they managed to see the property or not.
So the response would need to be qualified from commissioning. It certainly does not make it clear that there was a site visit.
Thank you. Any more questions? Councillor Allen, are you against this scheme?
I live opposite a residential children's, well, it's actually for young adults with additional needs. It's on Broadway, it's a busy road, it's a large detached home, it has space. We are disturbed in the summer, but the actual location is absolutely fit for purpose. I firmly believe that children with additional needs should be in the community. It's not the idea of having children in the community, it's this particular application that I have concerns with.
And if I may refer to you, the government's guidance is that children's housing should be in a residential setting. Do you not agree that this is a residential setting?
I agree it's a residential setting. I don't agree with the plans that suggest that is an adequate space for, and if it was 8, it says 8 to 18. We can't guarantee, we grant planning application on this. We say, or the provider is saying likely. If there's a need and a demand, then there's a licence available to put a child in that space. I disagree.
Thank you. Any more questions? Thank you. You could take a seat at the back. Right, now questions to officers. Ooh, Councillor Hopper first and then Councillor Sharp.
Thank you. I'm going to have to get you to use your wand or cursor again. Can you show me how staff would go to the toilet in the night? How they would access a toilet, please?
Did you say staff? Yeah, so it's here. This is the office, and you've got a shower room there with the toilet just there.
Thank you. That's the bit I couldn't see. I couldn't make out whether there was a downstairs toilet, so thank you.
Okay.
Councillor Sharp.
Thank you, Chair. I think if I'm reading this correctly, it's saying 2 parking spaces. Clearly the shift changeovers, it's indicating a maximum of 2 staff at any one time. So from my perspective, that would be a requirement for 4 car parking spaces at changeover. Otherwise, there's going to be untold chaos on a very small constrained front garden parking. Is that correct? My assumption correct would be a requirement for 4 because of the shift changeover, 2 arriving and 2 departing. Thank you.
Is that a question for the highway? Are you here? Thank you.
Thank you, Chair. Through you. Yeah, I mean, the parking requirements for this use would be 1 space per full-time member of staff. As you say, there'll be 2 on site during the day. There will be a changeover. There may be a need for additional parking at those changeover times. However, there is actually an existing drop curb into the rear garden of this property, accessed off, is it Woodlands, the road to the back? So there is scope for there to be hard standing introduced there for additional parking if that's found to be required.
Thank you. Councillor Hussain.
Sorry, yeah, just going back to the same question asked Councillor Allen, whether officers can tell me whether there was any site visits by, say, the services team.
As far as I understand, the meeting between Children's Commission was with them and the company that's going to be running the business, rather than actually diving in deeper in regards to the site, etc. Because all of that is actually covered by Ofsted when they do the assessment.
Thank you. Do you have a supplementary question?
I have some others, yes.
No, please do.
So LP13D, it mentions about improving access for those with mobility issues, encouraging cycling. There's no mention of cycling provision or cycle racks like we've seen in other applications. Would you say that the accessibility in this plan is acceptable for people with, say, wheelchairs?
I don't think we've got the wheelchair access in here, but in regards to the cycling, we have put a condition on here that prior to the implementation of the scheme, cycle parking should be included within the plans, and they need to be submitted to us to agree with before they go ahead with it.
Thank you. Do you have any further supplementary questions? Yeah, please go ahead.
I did have one just to clarify. The officer mentioned housing needs, and they said that there would be 2 children. But within that write-up, they didn't also mention that obviously there'd be also 2 staff members. So are they saying that 2 staff members within that office space would be adequate space for 4 people for this space, size of space?
The house would be lived in by the 2 children. There's maximum of 2 staff. You probably wouldn't expect 2 staff to be in the office at the same time if they're working and looking after the kids. But in terms of the layout, the internal layout, and whether it meets the needs of the children that they're applying for, would be an assessment by Ofsted, and they need to be following the registration process and the regulations of Ofsted that Ofsted look after.
Thank you. Councillor Hogg.
Just wanted to clarify something. It says the day shift runs from 7 o'clock in the morning till 10 o'clock at night. That's a 15-hour shift. Are they really expecting people to work a 15-hour shift? Or is there going to be some sort of handover? Is it going to be staggered in some shape or form?
The 7 to 10 is the information that we've got given, but I think the working hours and the way that the home is actually run, that will be an assessment looked at by Ofsted.
Thank you. You can, please, too.
Sorry, thank you, Chair. Through you, just to add to that, just to make it absolutely clear, the mechanics of how this children's home is run, shift patterns and things like that, are matters that are covered by other regulations and other law. How long people work in a shift pattern is covered by employment law. It's not something that the committee can refuse on the grounds that people might be working long shifts, if it's okay in terms of employment law. How the children are managed and looked after, whether there's enough space for staff, whether it's an appropriate place for these children to be, that's all covered by other legislation and other regulatory regimes, most particularly Ofsted. So regardless of whether planning permission is granted today for this, the operators still have to comply with all these other regulatory regimes, and that is a material planning consideration to take into account.
Just kind of explain the question, why I asked the question. So I absolutely understand that. But what we have in before us is the fact that they're saying that the vehicle movements are going to be happening at 7 o'clock and 10 o'clock. If that's not going to be the case, because actually those shifts are not, we've been told something that's not true, well then we need to adjust. It's about the vehicle movements. It's about whether or not cars can be parking on the property. It's not about the running of the home and how the home works. But the point is, I'm trying to look at the information that I'm being given here as part of the application, and I'm thinking that doesn't sound true to me, and that's the reason for the question. Because if this information isn't correct, what else on this application isn't correct? Is the point.
Sorry, Councillor, I'm not understanding which bits of information are you saying you believe are incorrect.
So the reason I asked the question about the shift working pattern was not about how how it works and whether or not it's Ofsted compliant or if it's compliant with employment rights, but I was just using a reasonability test to say the application says that there will be that the shifts will be running from 7 a.m. till 10 p.m. And I just wanted to know how valid that statement actually is, because it is a 15-hour shift. So I realise that in terms of employment and in terms of Ofsted, that's not something that we should be considering. But in terms of vehicle movements and stuff, it very much is something we should be considering.
Would you like to respond to that?
Yes. In terms of vehicle movements, I think the way to look at this is in the context of the street as it is. It's a residential street. You've got people coming and going at various times. Some people start work early in the morning, leave or come back at various times. So the type of vehicle movements that we're talking about here are not unusual or something that wouldn't be expected in a normal residential area. And as our highways colleague has already said, there's adequate parking and space for those change rounds of shift when they happen.
Thank you. Councillor Sharp.
Thank you, Chair. I think my first question was going to be around the suitability of the property, but I think Phil has pointed us down the direction, or pointed me down the direction that that's not relevant. I guess the second question was around the need. I think Councillor Allen made some questions about whether that there was some confusion and lack of clarity in some later statements applicant in terms of the need. I wondered if officers could just sort of clarify that those challenges that are made and what justification has been given by the applicant in terms of need. I guess I'm trying to imply that a question whether this is suitable in line with that question of need. Thank you.
Yes, so during the communication process, initially the company had not got in touch with Children's Commissioning, and eventually they did, and they had a meeting, and it was only after that that they confirmed that there is a need for it. I think with these types of homes, there is always a need for these types of homes, but in terms of where we get from Children's Commission, if they have concerns, they would tell us. If after they've met the company, I've got an email from them confirming that they have no concerns with regards to this application. So henceforth, it meets LP8, which is for the housing needs.
Got a further question?
Just come back, just clarity. Okay, so in their opinion, it's meeting the need, and am I right in saying, from those earlier comments, that the suitability is not a consideration for us at planning? Is that correct? We can't consider whether that building layout, because I wasn't on the site visit, but I read a lot of plans in my professional career, and that's very, very small for 4 people. Very small. But are you saying we can't consider that?
It's up to the applicant to prove to Ofsted. So after the planning application, it is then up to the applicant to prove to Ofsted that this place can do what it's setting out to do. So that's not for us to assess whether it can definitely do that. It's for them to prove to Ofsted in order to get their registration.
Thank you. Councillor Fitzgerald?
I won't labour the point on hours, Phil, but I think what he's saying is if there are 3 shift changes a day, that's another set of traffic movements. But if it's 8-hour shifts, because 15 hours is a little bit unbelievable, but not impossible. So I think the point really was about working 8-hour shifts, which would mean 3 shifts a day, not 2. But there is additional parking to the rear. That was confirmed? Yeah. I have a small question about, it's kind of related to Councillor Allen's points, and others raised the point about the suitability of the layout. Do we not have, in terms of whether it's building control or whether it's in planning, our own set of criteria for acceptable living standards in terms of planning? And I know the Ofsted thing will be the final determinant, because if it's not suitable, Ofsted won't approve it. But you would have thought, this is cart before the horse, you would think that somebody would ask the question before submitting it whether or not it's going to be approved, because there's got to be a set of policies or, what's the word I'm looking for? Guidelines or criteria, what is acceptable living accommodation in terms of the available square foot. And I'm wondering, don't we have that? That's my question. Is that not something that we have already?
So we don't have any specific policies about space standards. LP 17 is to do with amenity provision, and it includes amenity provision for future occupiers. And it doesn't give any kind of specification here. It talks about future occupiers should be, have adequate natural light, privacy, noise, adequate amenity. But there is no defined standards in there. So it's a matter of judgment as to whether something is acceptable in that
Maybe
sense
we should get some.
or not. I mean, that might be something that our local plans team might look at when they're reviewing the local plan. But at the moment,
or at least
there are no...
sorry, Chair, or at least use their guidance, the CQC guidance, or Ofsted, because if we commission care home places, they are built to a particular specification. And, you know, to me, I concur with Councillor Allen, it seems tiny, you know. But
I think we would have to, or you as the committee would have to have a very compelling reason to refuse on those grounds, and you'd have to have some evidence to that really stacks up that this is totally inadequate, and I'm not sure whether there is information or evidence available to you to make that decision. But as we said before, the adequacy in terms of it performing its purpose as a children's home is really down to Ofsted under their regulatory regime. And if it's deemed to be not good enough, then the operator won't be able to operate it as a children's home. So, you know, the granting of planning permission doesn't override the need to comply with other regimes.
Thank you. Any more? Oh, Councillor Jamil, sorry.
Chair, I seem to be leaning towards the arguments made by Councillor Allen. This is a home for children who've got emotional and behavioural difficulties. And it's something that Councillor Fitzgerald said as well. I just find it tiny. You know, if you're trying to help people, it just seems, in terms of what we've got there, it just seems that it's just been put together. And secondly, we've got a staff shower there. Do we have somewhere for staff to sleep overnight? Do we have? There's so much that I just think is not right about this application. I know we've given permission, but and I know that we need these, but we've got to make them as right as possible. But I am really struggling to find, you know, positives as to why I should say, yeah, I think this is the right one, because I just don't think there's.
Councillor Jamil, that's more like a debate. What's your question?
My question to officers is there any accommodation, sleeping accommodation for staff there, unless I missed it at the start?
Yes, this bit here is the office which doubles up as a sleep room for staff, and there would only be a maximum of 2 members of staff at any one time. So you could have 1 member of staff, you could have 2. If there was 2, they both wouldn't be sleeping at the same time.
Sorry, also, I think the committee needs to bear in mind that this has previously been used as a 2-bedroom house, as are most of the houses on that street. And I haven't done a survey, but I would guess that a fair few of those houses have 4 or more residents living there.
Let me try to make it simple. Is adequacy suitability a material planning consideration?
So the fact that there are other regulatory regimes, government bodies such as Ofsted, which control the adequacy of the internal layout and the care, etc., is a material consideration. And because they are government agencies, responsible agencies, we do have to make an assumption that the rules that they insist on are reasonable and in the best interest of both the staff and the residents.
Thank you. That answers my question. Councillor Sharp, this is the final question, and we go to the debate.
Thank you.
I
was going to ask a similar question to you, Chair, in relation to that, because obviously I asked the question earlier about whether it can be considered or whether it was Children's Services which Phil answered. And Councillor Fitzgerald mentioned cart before the horse. So my question is 17B, amenity of future occupiers, and those occupiers being the children and the staff, a consideration for this committee?
It's a local plan policy, so it carries full weight. It's not just a material consideration, it is part of the development plan. But the way I would suggest that you look at this is that policy requires a reasonable amount of amenity. It doesn't define it. There are no figures in there, space standards, etc. So it's a matter of judgment. And given that Ofsted Children's Commissioners are responsible bodies who have the expertise to determine whether, you know, what's an adequate internal layout, etc. Is there enough amenity for the residents and the carers? I think that is if you if you have faith in those regulatory regimes to make the right judgment, then that covers policy LP17.
So that's a yes, but there's a trap later, there's a catchment later, is what you're saying. So we can consider it now in debate, but what you're suggesting is defer it to others.
Correct. And as I said earlier, if you were minded to take a view at this point that it's inadequate in terms of space, etc., I think you would need to have a really compelling argument to refuse it on that basis when you've got these other regimes who will make that decision.
Right, I think we had enough debate on that. Our questions?
On all around the houses, this is a planning application. This is a house that has brought generations of people up, more than 4 people. Those people are changing. There's adequate parking. And the thing is Ofsted will have the final say. If they have to go out and spend £50,000 on a registered manager, and that registered manager can't hire the staff, then Ofsted won't wear this at all. This is a planning application. I was there last Friday, and the accommodation is perfectly suitable. And Ofsted will decide who is able to stay there. And they've even moved the office. If you look, they've moved it so that the staff are at the bottom of the stairs. So they've moved the kitchen to the back. They've even thought about where it's going to be. And I'm sorry, it ticks, for me, it ticks all the boxes, and I just don't know why we're going round in circles with this on a planning application where the final say for the sufficiency and for the much needed type of accommodation will lie with the regulator which is Ofsted, of which we're all keenly familiar. I'm sorry, I will be going with officer recommendations to approve this application without any hesitation whatsoever.
Thank you, Councillor Jones, but I think everybody's got a right to ask any questions whenever they feel comfortable, but your point has been noted. Councillor Hussain.
Thank you, Chair. I went to site visit as well. Yes, I thought the house was small. I know what Councillor Jones is saying. Yes, it's a planning application. The issue I have with this is that I feel like we're sort of passing the buck a little bit. What I mean by that is, so the commissioning team, from my understanding at the moment, didn't go to look at this house, and it's for children who we want to, as corporate parents, make sure that we do the best by them and provide the best service for them. So we want to provide them.
Councillor Hussain, did you say 4 children or 2?
2 children.
Okay.
I didn't say. Did I say children? 4.
You said
four children, not as in 4 children.
You
sorry.
meant 2 children.
Yeah, 2 children. So, for me, I don't think the space is adequate enough, as was mentioned earlier under LP17 about providing the needs for the future residents, for the staff and for those children, where the applicants also mentioned about the ages, just for registration purposes, being between, the actual ages will be between 17 and 18, but registration purposes they put 8 to 18. There's nothing to say that they can't then have younger children in there. Ofsted may look at this and say, well, the application for planning has been ticked, so now it's down to them, fair enough. But if they don't look at it and they just look at the company and the paperwork and it all matches, I don't think it's good enough for me, and so I will be minded to vote against Officer's recommendation.
Councillor Hussain, I think you're taking Ofsted very lightly. Councillor Hogg.
So yes, I went to the site visit, and I think that this is one of those cases where the site visit really does bring an extra element to what we do here with the committee, because you look at the plans and you kind of look at it and it looks all very well and dandy, but I found that house really quite oppressive. The staircase was very narrow. It was really quite steep. The size of the rooms as they stood were pretty small, and they're shoehorning in a second shower room up there. And it's a children's home for looked after children. It may be that it doesn't end up being children from within the PCC area, but ideally, we would be looking for a children's home. We would be looking to place children into ones in Peterborough. So, we have a corporate responsibility for those children, and these, it states here quite clearly that these are children with special education needs and disabilities, on learning difficulties or emotional and behavioural difficulties. It's quite an oppressive house. I take what Councillor Jones says in terms of, this house has probably seen a number of families go through that property, and has done them well. But that was a family of maybe 2 adults and 1 child, maybe 2 children at a push in the second bedroom. That's a whole different ballgame from 2 children that are essentially taking up the whole of the upstairs, and then downstairs you've got 2 adults there 24/7 working in those conditions. And my conscience, unfortunately, this is where the heart kind of overrules the head, maybe. But my heart is saying, can I, with all conscience say, yeah, this is fine as a children's home. I get that it's adequate for a family of 4. Really at a push. But we should be putting a higher standard on the accommodation for what is a commercial operation. In terms of, if there's a commercial operation, you have to have fire doors, etc. There's a whole load of rules and regulations that come alongside commercial versus residential. And I think, as I said, for me, that staircase was very steep and very narrow. And if you're dealing with children with problems and issues, as has been evidence that that they're saying that actually these are going to be teenagers, I've seen issues around these kind of homes where children with behavioural problems going into them cause a lot of problems in terms of acting up and windows smashed, police coming to deal with set twos and what have you. And I just think that kind of close situation, it just doesn't help that situation at all. I'm either going to be voting against or I'm going to be abstaining because I can't put my name to this as an application.
Thank you. Councillor Sharp.
Thank you, Chair. Yeah, I do understand completely the comments that Councillor Jones has made. I perhaps wouldn't be quite so vexed about them, but I do completely understand this as a planning consideration, which is why my questions for officers have been trying to clarify what is considerable in planning. Now, as I'm saying this, the reason it's in front of us is because it's a change of use. It's a change of use from C3 to C2. So we are right to consider the amenity of the future occupiers and whether that is suitable. In my mind, admittedly, I wasn't on the site visit, but I've heard from what other colleagues around the table here have said. And as I said earlier in one of my questions, I've read a lot of design plans, and that is no more than a box for 4 people. So from my consideration, I don't believe that it's met the amenity criteria for future occupiers, and because it's an application for a change of use, I'm minded to refuse the application to support Councillor Hogg's comments. Thank you.
Any further debate? Oh, sorry, Councillor Warren and then Ms. Sharp. Thank you. Sorry.
Thank you, Chair. I find myself in a very difficult kind of position here because I kind of agree with Councillor Jackie Allen's sentiments as well. I don't agree with the design or the actual outline of this property, but we have to consider this as a planning application and a planning for. We understand, and if you've ever been through offset inspection, you'll understand how bad they can be. So I'm mindful to go for this application, even though I don't agree with the design. I have to take in the views of the officers, and this is not a planning planning aspect of it. So I have to trust that Ofsted will get this application right and get the building suitable. We are corporate parents. We need to have high standard, high quality children's care, and that's why we have Ofsted. Ofsted will do their best to make sure that we will have this property, this plan, into the standard that we require. So therefore, I will reluctantly go for the application and agree to approve this application.
Thank you. Councillor Fitzgerald.
Thank you, Chair. So I don't agree with Councillor Jones that we've been going around the houses. I think we've had some interesting questions and now we've got interesting debate. I think when I went on the site visit, so I know, I went upstairs, it was very, very tight. So I think from a planning perspective, officers need to take back to the planning team that somehow we must write into policy that an application of this type must already come with specifications, because we're now being asked to decide on the specifications in the absence of any specification provided by Ofsted or anybody else. So I was minded to go with it, but I think I'm minded to go against it. So the issue is really that we're being asked to determine whether that's an acceptable residential amenity. And I can concur with Scott said, we could pass the buck and let Ofsted deal with it. But would I want a child to live in there, particularly one with special needs, and I don't know whether they've got special needs or not, or whether they're in some kind of disability. So that, to me, is not an acceptable design standard, which is why I'm saying cart before the horse. They come here and said, we've done all that already, and Ofsted have said our plans are fine, just subject to planning. Make my life much easier. So I'm now in a quandary as to what to do. Thanks, Chair.
Thank you. Any further debate? Councillor Jones.
I think it's not so much going round the houses, Councillor Fitzgerald, and there has been some useful debate here. The fact of the matter is that, you know, if it was a HMO and 3 or 4 people could live there, have as many vehicle movements as they like, this will be a regulated, a much-needed regulated place that Ofsted, and again, the people placed in there, if they change, then Ofsted will have to re-review it. Unlike a planning application, the house is the house. And this is where I'm sorry, I just can't get on board with people's understanding of it. We have the planning officers who look through this and were saying, could 4 people comfortably... Okay, it's not ideal. But I remember other applications in Hampton, in Alton Waterville that have been kicked out, and they've been, in my eyes, much more suitable premises, either on vehicle movements or on people wishing to change them. In this particular instance, I think that, again, our officers have made recommendations, and obviously the people who will be in there will be subject, so the planning is what we're being asked to judge, and then any further, you know, subject to the people who are moving in there, they will be the people that Ofsted will be looking at, and the qualifications and suitability of the staff. I don't know why we're going that far looking down the road. You know, we've just passed an application for a garage about vehicle movements, because just because we don't like something doesn't mean to say we can't approve it. Surely this falls in the same line. I think we ought to be going with officer recommendations, or, as we saw in the first one, this could easily go to appeal, and I think it will be easily overturned, my view.
Thank you, Councillor Sharp. You want to come back in?
Yeah, and I think thank Councillor Jones for his comments, but I refer back to mine earlier. It's a change of use. We have a duty to consider its change of use. So we have a duty under LP 17 to consider the amenity of the future occupiers. I would challenge anybody in the chambers and in the members here, do we feel that that is acceptable, an acceptable property for the future occupiers? And I hear the comments Councillor Jones made about properties in Hamptons and so on, and I'm aware of 1 or 2 of those. They were certainly suitable for the occupiers. They were rejected on the grounds of amenity for neighbours and parking, so different issue. So I would question members, do you feel that is suitable for 4 people at any one time, 2 of which could be vulnerable young adults? Thank you.
Thank you. Any further debate? No. Okay, I'm going to say something about this. Hang on. Sylvia, do you want to come in? Oh.
Yeah, would you like me to assist at all, or would you like to say your piece and
It'll
then come in later
It'll
on?
be an honour. If you could do that, I'll make my comments at the end.
Yeah, okay. I've heard the debate that's taken place around this application. I can see that members are very exercised about making the right decision, and clearly you're very concerned about the suitability of the property and making sure that we're not granting permission for something that might be very detrimental to vulnerable people that could be living in this property. I would, I suppose, just draw your attention back to the fact that you are a planning committee and you need to be concerned with planning matters. So that would cover things like the suitability of this location for this particular type of use. I think you're all agreed that it's in a residential area, and this is the sort of place where you'd expect to see a small children's care home to help the residents live within the community. I think you also have to be guided by the planning policies that are available to you, whether they're national policies in the NPPF or local policies set out in the local plan or a neighbourhood plan, as we've heard earlier today. Now, if you've debated LP 17, particularly Part B, which talks about amenity, and that provides quite general guidance to you. Now, I sort of feel that the committee would like to see something more specific in the local plan, a specification or something more precise. However, if that policy isn't there, then we can't sort of invent one. You have to really make your decision based on the policies that are currently available to you at the moment. Whether there's a need for that kind of policy, given we've seen an increasing number of these care homes in a new local plan, is something that we can take forward, but at present, we don't have anything beyond LP 17. You've heard that there are other regulatory bodies, and that's really a significant material consideration that you do need to consider. I think you've all become aware and experienced in the fact that planning policies and planning regulations are not the only thing that covers uses. There are lots of regulatory bodies out there, some within the council, like environmental health, food standards. There are others that are governed by organisations outside of the council, and there does need to be some trust that they will do their jobs properly, and that things will be covered by their regulations. And I think just finally, this is the first children's care home that's come before committee for some time, and we have had them in the past. But we do receive quite a number of these applications now, and we deal with them under delegated powers mainly, where they're not called in. So we do see quite a few of them, and we are seeing an increasing number that are in smaller properties like this, given the type of housing stock in Peterborough. So in the past, where we might have seen large detached houses with grounds as being suitable for care homes, we are seeing them in a number of smaller properties increasingly nowadays. So I just hope that maybe helps in terms of context, and really, whatever decision you make, it needs to be based on evidence, and it needs to be substantiated as well, given that any refusal may go to an appeal, and particularly bear in mind if we've determined other such applications under delegated powers, that kind of consistent decision-making needs to be considered. I think the last thing I would say is if members did feel it very difficult to make a decision now, a deferral of the application should you require further information that officers can bring to you. So say, for example, you'd like to see a comparison of the sizes of properties that have been approved elsewhere, or further clarification from Ofsted or from Children's Commissioning to assist you in a decision, that's also available.
Thank you, Sylvia. That's great. Thank you for your input. I had specification. Oh, sorry, Councillor, you want to come in?
Sorry, Jay, I didn't mean to interrupt you if you're just in debate, but if you want to,
no, you are you wrapping up? Then
I need to come in. I totally agree with what the officer has just said. that is it our task to look at that as corporate parents? Well, I guess it is in a way. Of course it is. We have to look at it that way. But also, there are, as has been said, there are bodies that have that responsibility, and that isn't us, to sort out size. I'll give you a little thing. I just had a quick research on this, and the reason I bring this up is because there's lots of people have bought family homes that got smaller rooms than that for their children in it. The minimum standard is a 6.5 metre squared minimum floor area. The smallest room in this house, thank you Councillor Hogg for sending me the numbers, is actually a 7.8 metre square floor area. So it meets building standard. And that's notwithstanding, of course, you know, the corporate parent bit about the type of needs of the person in there. But that, I don't think, is our decision. I think that decision is an Ofsted decision as to whether that size room is suitable, you know, for the child's condition, whatever that be at the time. So I'm not going to go down that line. The Children's Commissioning, if we look back at the report, don't raise any issues. They actually say there is a need, but they don't raise any issues in their report to say we're worried about size or anything like that. And I think, yeah, certainly, I think if you're going to go that way, I would suggest, just purely from my point of view, if you're not satisfied, that you do look at previous examples and ask for this to be deferred. Currently, I am satisfied and I would support officers, but if other people are not, then I would, yeah, suggest that you ask for further information. Thank you, Chair.
Thank you for your input. Specification, I made a note of that, and I think Sylvia's covered that rightly, that if there's no specification in place, we can't implement it. So we are where we are. Now, I think what we need to look at, I think it's important that we divert our attention to the Minister's statement of May, where, you know, supplying residential settings, it's a material consideration. What's the guidance of the government? That children should have a suitability housing in a residential setting. So it meets all that criteria. And now, when we talk about Ofsted, you know, we were talking about a serious organisation. You know, imagine officers coming to the council for an audit. These officers will have sleepless nights. And we're not giving enough weight to the Ofsted. Ofsted is a serious business organisation who deal with matters seriously. Now, talking about the children's vulnerability and safeguarding issues, they will deal with them. They're the best people who deal with it. So we shouldn't be, you know, feeling that, oh, you know, we're giving it in the hands of an organisation who are not competent. They're very competent and very able. Now, yes, officers have said, we've got other regulatory bodies, government bodies. They're not private bodies, they're government bodies. And I'm sure they've got set standards which they have to follow. So we should have some faith and trust in those regulating bodies. And I think by mentioning them, I think it discharges certain of the pressure of me that I've got faith in them and I will trust them and they'll do their job properly. So there is a need for a house to sort of scheme in that area. It's made it clear from the Minister's statement, government guidance on it. Now, we've got to be very careful that if we go against it, we have to give reasoning why we're going against it. We just can't go against it for the sake of it. So we've got to bear that in mind. And we've got to bear in mind that it could get challenged. And you've got to bear one thing else in mind, that the officers have had delegated powers in the past to do those applications. You know, and then what the applicant will be doing, he'll be making comparisons. And in response to your question or concern, Jamil, that, you know, it looks small, but if you went on the site, you know, it does look small, but if you go on the site, it's a reasonable good size. You know, your view would have changed only if you'd written there. And Councillor Sharp, I'm sure you didn't attend. Oh, okay. That says it then.
Excuse me, Chair. As I stated earlier,
I've
read a number of plans, so there's no need for that.
Yes, I'm encouraging.
Thank you, Chair.
I'm encouraging, and an ex-chairman used to encourage that we should go on site visit. It makes a huge difference. I'm just speaking for myself, and I encourage everybody to go. So, I think if members are not minded to support the officer's recommendation, deferral would be the best option, taking into account everything, whichever information that we require, you know, for the assistance, we ask officers to provide, and then we defer it to it. So that's my suggestion to the committee. Councillor Sharp, you wanted to come in?
Thank you, Chair. Yeah, it's just picking on one or two points you made there. I'd just like to clarify. I mean, at no point am I saying that other authorities or other responsible bodies that may come further down the line aren't competent to make the decision. The point that I've been making all the way along is I believe that there's a planning requirement for us as a planning committee to consider whether the amenity of the property is suitable for the future residents. So that's what I've been suggesting all the way along. I never like when we have a responsibility, whatever body you're involved in, I don't like deferring it to others just in case when we have a responsibility to consider those specific points. Just picking up on the last thing you said, before you said it, I was going to make a suggestion, proposal that, based on Sylvia's comments, is it sensible for us to defer this, subject to a report, a suitable report going to officers from the applicant that demonstrate that it meets the need, whether that's in an Ofsted report or something that's akin to that. And on the basis, if that's acceptable, then it can be delegated powers and doesn't need to come back to committee. It's a proposal that perhaps I'd look to see within debate whether there's any support for that.
What do members say about that? What's their view? Councillor Hopper.
I'd need some clarity on that because it's been referred to committee for a reason. So would it not be committee that has to sit and make the decision whether they're happy with the report rather than go to officers of delegation because we've made that decision, so why should we force that on officers to make the decision? You know, we're saying, so I'm not saying I'm not happy. Members are saying they're not particularly happy, so that it should be them that make the decision at the end, based purely on that one thing. And obviously, because as you know, if you defer, it's that item, not the whole thing again.
Thank you. Do we need some legal advice on that? It's been a long day. Everything's frozen.
Shall I repeat what I said?
You want Councillor Hopper to repeat the question?
Yeah, I think I'll...
Yeah, please do, Councillor Hopper.
Yeah, okay, Chris, we'll do it in two sections. It's not a proposal yet, but the idea has been put forward to defer the decision, but it was mentioned that to look at more about the amenity side of it and some examples, but then it was mentioned to give officers that right under delegated authority. I've asked for your advice that surely if it's come to committee to make the decision, and committee are asking for us to defer the decision, committee should look at the new decision and it not be given to officers under delegated authority. Would I be right?
If you could put your mic on, please. Thank you.
Sorry, perhaps it's fine. So it's not about deferring it, it's more about if it's deferred, should it come to committee rather than officers make the dedicated decision, which I'm a bit more uncomfortable with.
Yeah, sorry, I'm with you. That's $1,000 question, isn't it?
Chris, if it's of assistance, I would think my suggestion was for deferral for further information in order to assist the committee with its decision. So not to defer to officers, but to then bring that information back to committee.
Yeah, I think come back.
Now, if I can remember the second part of my question, I'd ask you that as well.
Thank you, Councillor Shaw.
Yeah, I mean, it's a fair and acceptable challenge from Councillor Harper. I understand that. All I was trying to do was, if we were looking for guidance to a specific set of criteria, and that criteria met something that was already stated here, I was trying to avoid our councillor's time in terms of bringing it back. But for instance, if the applicant came back with an Ofsted tick, an offset survey and a tick, why does it need to come back to committee was where I was coming from. But I guess we would then have to dictate what that would look like. So I'm kind of happy to take what Councillor Hubb said.
I think Officer was coming here.
On a personal level, if I may say, Chairman, I'm surprised that there aren't published guidelines to help officers, because they've made a recommendation in good faith, and some very good questions are being asked. And I'm just surprised there isn't something officers can turn to, and putting it off for a month or whatever, 3 weeks, would give officers chance to consult the powers and then come back, I wouldn't say better informed, because these details are not available readily anyway, it seems to me. It's not as if you can Google it. I bet you my pension, you can't do that, or maybe you can. So I think, and yet I do think it's a committee decision, something so important. And the committee do seem to have given it, if I may say, before I wandered off, answering my boss, who's asked, I do think it's the committee who should make the final decision. Yes, that's a long answer, but yes.
I think you want to come in?
Thank you.
There is some government guidance on children's homes. It does say that the design should include adaptations to meet the needs of the children. So they don't have it specifically. From the guidance that I've read online, it's not specific in dimensions. It's suitable adaptation to the needs of the children. So these guidelines are, they're assessed individually. They're not set because it's catered to the needs of the particular children that live there.
Councillor Fitzgerald.
Sorry, we've come back to where we started on guidelines. So, Denison, now we'll agree we are going around in circles now. So, specification, guidelines, whatever you call it. The dilemma is, Sylvian, with all respect through you, Chair, is that we are being asked to determine whether that's suitable based upon what we have in front of us, and I have no idea, because I don't run children's homes. So, if there's a pause, and I don't care who it comes from, that our children's team can say, in our opinion, this is suitable. Great, because we are being asked to determine something as laymen in that sense. So I'm at the point where I'm so bamboozled, but can't we get from our children's team a definitive, yes, councillors, this would be suitable for the proposed use?
Thank
you think they would know more than we do?
Okay. Sorry, you want to come in? Okay.
Sorry, just want to say, in terms of the process, they need planning permission before they apply for Ofsted. So Ofsted won't actually take their application without a valid planning permission.
Could I ask?
Thank you. Councillor Hopper?
Yeah, I don't want
And
to
there's
keep
a
going in circles.
last question.
But
We're going to go to a vote.
I'm trying to bring this to a close, as everybody is, I'm sure, without going around in circles.
Thank you.
But maybe even legal can do this now. Maybe, Chris, you can do it now. Sorry, pick on you. But is it our job to be looking at the physical size of these rooms, or is that not our job?
I'd have been surprised if it is, having been in the job.
Can I? I mean, to me, this is very important.
Yeah.
Are you saying that we should not be taking into account the size of the rooms, or we should, in your legal advice?
I think given that there is a concern, a genuine concern amongst members, that we should. I haven't seen it. Members have seen it. And it's a very specialised use. I'd never been inside such a building. And I can only imagine how much space you need, although by what I've heard, the rooms are not tiny. It's just not a spacious property.
Councillor Jones.
Thank you, Chair. One of the things is that what we can't speculate on is the ratio of staff. So what and I think the question has been answered to the extent of Ofsted won't look at an application until they have planning permission. And if the nature of the people in care means that the ratio of staff has to change, then it will not be deemed suitable or adequate for those purposes. So I think then we're starting to put the cart before the horse. I think the question's been answered. Without the planning application, they cannot go forward, irrespective of the cost, irrespective of the staffing regimes. And I'm just suggesting that now the question's been answered, can we move to, please, a vote and put this to bed?
Thank you, Councillor Jones. Before I allow Councillor Hogan, that's the last person I'm going to allow. Phil, you said you wanted to say something.
Yes, please. Yes, thank you. Through you, Chair. So if members were to defer this, we've just established that we can't go to Ofsted and get them to say, yes, it's okay, or no, it isn't, because there has to be a planning permission in place first before they will engage. We have been in consultation with the Children's Commissioner, who have not raised any objections. If they felt, because they've seen the planning application, if they felt that this was way, way too small, not adequate, they would have raised that with us at the time. So if this were to be deferred, I'm not sure, you know, who are we going to get another answer from? Because Ofsted won't engage until the planning permission is granted. Children's Commission has already not raised any objection. And just going back to policy LP17, I think it would be very tenuous to refuse on those grounds. Just reading the policy again, it uses this word should. Yeah. So, and this is very much a policy about using professional judgment to come to a conclusion. And it talks about it should include adequate amenity for the living and storage needs of prospective occupiers. And as I said before, I think you would have to have a really compelling case, evidence case, to justify a refusal on the grounds of it doesn't meet policy LP17, particularly when you've got, as we've already mentioned, these other regulatory regimes who are not going to allow an inadequate facility for children. And yeah, again, just reiterating, the granting of planning permission does not override the need to comply with other legislation.
Chris, would you like to come in?
Yeah, there's also the question of a cost risk if we refuse and then they appeal. There is a possibility, it's not overwhelming, but that we might end up paying costs. So we're all trying to, or you are trying to make the right decision, I can see that. But it seems that we'd be less vulnerable if we granted it, because the applicant still has the problem of getting the thing up and running.
Thank you, thank you.
So, thanks.
Councillor Hogg, I'm just going to allow you, and try to make it short, because we've had enough debate on this, and I want to come to a conclusion. Please.
Hopefully it'll be a very short question. If this was a new build, would it be given planning permission in terms of the stairs, in terms of the narrowness and also the angle, and also the width of the doors?
Yes. Question to the officers, is it? Is a question to the officers?
Yes, question for officers.
Yep. When it comes to looking at new builds, internal arrangements, it's grounds to refuse something we thought a door wasn't wide enough, even if it wasn't wide enough to fit the building regs. Again, another regulatory regime that has to be gone through. Space standards, there's such a thing called the nationally described space standards, which is standards which are set by the government, but the government says very specifically you can't use these unless you've got it written into your policy, into your local plan. And in order to put it into your local plan, you have to have evidence to justify the need for it. And in our local plan, the only time when space standards are applied is on affordable rented properties. And that's based on an evidence base that's necessary for those particular types of properties, taking into account what's available. But with new builds, as I said before, in order to refuse something on what's considered to be an inadequate space standard, you've got to have a really, really strong space. It's difficult to draw that line, you know, at what point does it become inadequate? But it'd have to be something really, really bad to justify a refusal, unless you've got that policy in place.
Thank you. Right, now we're going to the vote. Right, three options. A proposal. Three options I think we should consider. One is we agree with the officer's recommendation, we go against them, or we defer it. Listening to evidence and listening to the explanation the officer's given, I am not minded to go with the deferral. Why? Because what are we going to achieve out of it? Nothing. We're not going to achieve anything out of it. Going against it, high risk of it being challenged, and we have to bear the cost. So, in a nutshell, I'm minded to go in favour of the officer's recommendation. Now, if anybody wants to disagree, we would like to have a proposal and move to the vote now. We've had enough debate on it.
I've got
Councillor
one.
Hopper.
Do you want to propose? Okay, fair enough. Listening to all the debate and listening to the legal officer, which of course, yeah, we could get costs, but that would be really based on being unreasonable. I don't think we're being unreasonable, to be fair. But you could still get them. But that's not a reason for us to say yes or no. For me, there are people that can do this, that are, you know, responsible for this sort of thing. It passes current building standards for the size of bedroom, as I've already said. So I'm not minded, I'm going to say my proposal is go with officer's recommendation and subject to conditions as stated.
Do you have a seconder? Councillor Jamil?
Yeah, I second that we go with officer recommendation.
Right, all those in favour, raise your... Against? Abstention? Karen, if you could read out the result, please.
Thank you, Chair. We do have 6 in favour, 3 against, and 1 abstention for the to go with the officer's recommendation. Therefore, is carried.
Thank you very much. Now, I'm not going to say this, but I want to say it because it's literally freezing. I need to have a bit of movement. Would you agree with me? Have a small break? Yeah. Not
Yeah,
it won't be a lot.
small break,
Small
yeah,
break,
please.
about 5 minutes. Right, can we make a start, please? Item 5.2. If I could ask the officer to introduce the item to the committee, please.
Good afternoon, thank you, Chair, and thank you to all of you who have helped facilitate me seeing my child's play this afternoon. He was a wonderful sheep. Thank you for that, and apologies for that delay and inconvenience, but it's very much appreciated. So the proposal before you is for an open windrow composting facility, or OWC, or compost facility, located at the Ivory landfill site. The compost facility is proposed for the area within the red edge on this plan, and the blue edge is the wider landfill site within which it sits. The village of Eye is to the northwest, and the site accesses the public highway at Ivory Road, which connects to Oxney Road to the south, which you can see there. To provide some further context for you before I describe the proposal, on this slide you can see the restored quarry areas. They're highlighted in yellow. Areas subject to landfilling which have been restored already include the northern, northeastern and central areas. And the active or current landfill area is that which we know as the southern extension. The permission for the southern extension allows for infill until the end of 2025, with a further 2 years allowed to complete restoration. That permission allows for up to 180 HCV movements on normal working weekdays, and for comparison, historically, when the quarry areas were active alongside the landfill, a total of 430 daily HCV movements were allowed at the site. The pink shaded area is that which is subject to a pending application for an eastern extension of the landfill site at what is known as Willow Hall Quarry. The Local Highways Authority have objected to the proposed landfill extension, and that application will be brought before committee in the new year with a recommendation for refusal on highways grounds. So this slide shows us more clearly the outline of the site and its location next to the southern extension. The red line includes the compost pad, which is that shown in grey. Sorry, just bear with me a second. And just to the northwest of that, you can make out the outline of the recycling shed here as well, which is important. And this is an area adjacent to that which provides parking and turning of vehicles. This slide shows the proposed layout of the composting operation, with those activities that will be subject of permit control being shown within this red line. The proposal is to compost some 50,000 tonnes per year of biodegradable wastes. This would be green waste of the sort you would put in your brown bins at home. There would be no food or catering waste and no other animal byproducts. The composting operation will be undertaken on a concrete pad, with the waste being brought onto site, placed in the reception area, being screened and shedded and placed into rows. Operations are proposed to take place between 7 AM and 6 PM on Mondays to Fridays. The pad will be curbed with a shallow gradient to contain and control surface water, which will drain to new lagoons, which are to the north and to the south of the pad as part of a self-contained system. The windrows of compost will be turned as required, with waste decomposing naturally under aerobic, that's with oxygen, conditions at temperatures up to 65 to 80 degrees Celsius, and that helps destroy weeds and pathogens. There will be up to 30 rows, each reaching to a height of some 3.5 metres, which will be managed and monitored throughout the process to produce approximately 25,000 tonnes per year of compost product to a PAS quality standard. Taking the 50,000 tonnes of feedstock and 25,000 tonnes of saleable product results in a requirement to move 75,000 tonnes of material per year to and from the site. Given it will be operational for 6 days a week, this results in an average of 2 HGV movements per hour. We're therefore looking to control HGV movements by condition to a maximum of 30 per day. And you'll have seen in your update report that we've made a slight amendment to that condition to allow extra precision on that to make it enforceable, and we can require weighbridge records, and we've got a good ability to monitor that so we can keep a good check on those vehicle movements. This slide shows the red line of the composting operations as required for the purposes of the environmental permit. The middle dotted orange line here, which I'm pointing to, that shows a 250-metre buffer, and this is the distance under which a standard rules environmental permit could be applied for. The 250-metre distance is one you may be familiar with from our Minerals and Waste Local Plan, as it is the distance at which our waste management areas are set. I.e., 250 metres is the distance at which we would ordinarily consider a waste management use to be acceptable as a land use from nearby sensitive receptors. It is, so to speak, our line in the sand. The nearest sensitive dwelling is this property to the north of the site. It's shown in blue up here. And that is just over 250 metres from the edge of the proposed facility. The application has been accompanied by a bioaerosol risk assessment. This identifies risk mitigation measures, and the significance of risk from the proposed site operations is deemed to be acceptable. The site would also be subject to environmental permit control, and the applicant has secured a draft permit. An odour management plan detailing management methods, potential mitigation measures, monitoring and complaints procedures will also be required and controlled through the permit system. We are assessing the suitability of the proposed land use through the planning system, and we are reliant on the permit system to control the processes and emissions. It is important to understand this site and proposal within its context, and although this is a similar plan to the one that I showed earlier, it demonstrates the underlying mapping of the area with aerial photography, so it just gives you a better indication of how it all fits together. In conclusion, the proposals are consistent with a spatial strategy for waste management and will contribute to driving waste up the waste hierarchy. The impact of the proposals have been clearly presented within the application, and the proposed use is subject to environmental permitting controls. The applicant has secured a draft permit from the Environment Agency, which will control the processes and emissions associated with the facility. My recommendation to you is that the application accords with planning policy and the permission be granted with the relevant conditions as outlined in my report.
Thank you for your report. We have 4 people registered to speak on this item. Firstly, I would like to invite Councillor Nigel Simons and Stephen Allen to address the committee. You will have up to 10 minutes between you in which to address the committee. The Democratic Services Officer will let you know when you have 30 seconds left and when the time has lapsed. When you're ready, if you can please switch on your mic and start speaking. Thank you.
Yeah, thank you, Chair. Yeah, thank you, Alan. Yeah, well, I'll speak a bit clearer. My concerns are obviously highways. I'm pleased to see that the other extension is going to be refused, which is great news, because anybody knows that road. It's a single carriageway with passing places. It's a very busy road. This committee also have approved outline planning for 270 houses on that road. So we have real concerns on traffic. Alan's saying it's only 30 extra vehicles a day. Well, 30 extra, it's too much. To be absolutely honest, most of these vehicles now, if you go that way, I don't know if you saw them when you visited site, one of those vehicles fills one of those passing places. Now, in our opinion, and we're not highways experts, that road, that single carriageway is not fit for purpose for that site at all. And we honestly believe that. So I'm pleased to say that the extension is obviously hopefully going to be refused. But I also have issues with the odour. How on earth can we say that odour is not going to go more than 250 metres? That's just diabolical. If you want to visit Waterbeach and speak to people, or even Google Waterbeach, or even the Crowland area, where there's similar facilities, there's an awful lot of complaints about odour. I'm sure any member in here would not want this facility within 250 metres of any of their ward. And to be honest, I'm very disappointed that we always seem to get lumbered in the rural wards, in and things like that. I think there's better suitable areas for this, more rural than this. This can affect and Palmel. How are you going to stop the odour? I just don't think that's going to happen. Thank you. I hope the committee will go against Officer's recommendation and refuse this application. Thank you.
Councillor Allen.
Thank you, Chair, and thank you, Mr Jones, for a comprehensive and eloquent presentation. I'm here supporting objections of the local residents and Parish Council. There are clearly two issues of concern: noise, dust and odour, and increase in vehicle movements. The residents of have understood that with the extraction worked out and the site returned to nature, they could look forward to some respite from the impact of heavy vehicle movements along Ivory Road. This road is clearly not fit for purpose. I mean, take a drive down there, any member of the committee. In the main, an uncontrolled single-file country lane with spasmodic passing places. It really is under pressure at all stages of the day, primarily the morning and evening commute. This application sees the resumption of what effectively will be industrial use to that road, where the residents thought they would see some respite. The pressure of the road, which is a congested rat run between the A47 and Peterborough's Eastern Industry, will be further impacted by the pending industrial development at Red Brick Farm. This, together with the vehicle movements generated by the proposed composting site, is unacceptable, frankly. In addition to the road concerns regarding vehicle movements, we have the threat to the amenities of local residents with the noise, dust and odours which will occur. Locations elsewhere have seen complaints and objections from nearby residents with, in some cases, the need to enclose the activity of composting to mitigate those issues. We urge the committee to recognise the concerns of those in village and nearby neighbourhoods and refuse this application, at the very least condition covered operation for the composting and a restriction on the number of vehicle movements. Thank you, Chair.
Thank you for your address. Committee members, do you have any questions for them? No questions. Oh, sorry, Councillor Hopper.
Yeah, sorry, councillors. Just you mentioned housing development as well. Or were you talking about Red Brick? Just wanted to double check.
No, the Ivory Road development, 270 houses. Allison Homes.
Thank you, Chair. Thank you.
Thank you. Any questions? No. Thank you very much for coming. If you could just take a seat at the back. Now, can I ask Chris Godridge, as an objector, to address the committee? If you'd like to take a seat here. You will have up to 5 minutes in which to address the committee. The Democratic Service Officer will let you know when you have 30 seconds left and when will the time has lapsed. When you're ready, if you can please switch on your mic and address the committee. Thank you.
That one? Brilliant. Chairman, ladies and gentlemen, thank you. I'm not as eloquent as you lot obviously are, so I'm going to read out what I wrote down. Firstly, I'd like to say that I have nothing against Biffa's wish to recycle and make compost. Also, for many years, I've maintained a good relationship with Biffa because they're my neighbours. However, when it comes to this particular project, my main fear is the risk of the bad smells. My family and I are approximately 257 metres from the composting site, And as Nigel pointed out, the smell doesn't go 250 metres and stop and go southwest or whatever, as you know. So my family and I live approximately 257 metres from the proposed composting site, which puts us in the firing lane if there are any problems with smell. Could it be moved further away, say 400 metres from where I live? I do not wish to be standing here in years to come having failed to point out to this committee that I did nothing to point out the potential problems. There should be very strict guidelines implemented to reduce the effect it will have on our community if this proposal is passed by the committee. Would it be sensible to give Biffa a short-term agreement in which time they could prove that they can control smells? Say a review every 5 years. Thank you for your kind attention.
Thank you for addressing the committee. Members, do you have any questions? Councillor Jones.
It's very magnanimous of you, Mr Partridge. Would you, and thank you for your address, are you saying that you're happy to go 5 years with this, or would you prefer something, you know, where does that figure of 5 years come from? It sounds a long time to me.
Yes, it is a long time. Well, I was drafting it this afternoon with my son, and it's just a figure out the sky. Obviously, they're not going to spend a lot of money, and with the knowledge that in 2 years' time it's going to be closed down. So, yeah, I'm not a surveyor. I don't know. 5 years just seemed fair. That's yeah.
Thank you. Councillor Harper.
Yeah, thank you. Could I ask your views on the traffic on the road?
Yeah, well, it's much the same as Nigel said. It's a very busy road. You know, anybody who goes down there will see that it's quite difficult. You know, out of the two developments, would I prefer the composting or that? You know, there's less traffic with the composting. That's the simple answer. Thank you. Yeah.
Thank you. Councillor Hussain.
Thank you, Chair. It was just regarding the current work that's been happening at the site. I know we're not considering that. I just wanted to see if there was any impact from that to your residents at the moment, like as in noise, or is there any noise or sound as in or smell pollution from their current activities?
Not significantly, no. Of course, when the wind changes and we get a southerly, then you do get noise and occasional smells. So the direction of the wind is quite important. Yeah.
Thank you. Any further questions? No? Thank you very much for coming. If you could just take a seat at the back.
Thank you very much for being patient with me.
You're welcome. Thank you. Now, can I ask James Stewart Arvin, the applicant, to address the committee? You will have 5 minutes in which to address the committee. The Democratic Services Officer will let you know when you have 30 seconds left, and then the time has lapsed. When you are ready, if you can please switch on your mic, which is already on, and start speaking. Thank you.
Okay, yep. Thank you, Chair, and members of the committee. My name is James Stewart Irvin, and I'm a planning manager at Biffa, and I'm also here with my colleague from Biffa's Resources and Energy Division, who manages the site, and others. Firstly, we would like to thank Mr Jones for his diligence during the determination of this planning application and for the comprehensive nature of the report that is before you today. We welcome and strongly support the recommendations of officers. Landfill has been an active area of mineral extraction, backfilling and restoration since the 1960s, with Biffa commencing landfilling operations in 1982. Today, Biffa undertakes various waste management operations at the site, including disposal, electricity generation utilising landfill gas, waste transfer and recycling. Biffa has also developed and fully manages a wildlife corridor and the Clearwater Lagoon and other water features at the site. Biffa undertakes waste management operations across all levels of the waste hierarchy, including a well-established organics recycling business within which we operate a number of open windrow composting facilities across the country. This operation expanded with our acquisition of Viridor's collection business in 2021. The principle of establishing a facility for the treatment of biodegradable organic material at this location was established through the grant of planning permission for an in-vessel composting facility in 2015. Since that time, government policy through the Resources and Waste Strategy is moving towards the separate collection of food and garden wastes and to continue to ensure that garden wastes are diverted from landfill. Open windrow composting is a suitable technology to meet the growing needs of local authority and commercial customers as more local authorities begin to commence separate garden waste collections. There is local demand for high-quality compost from open windrow compost processing. Providing facilities to maximise the value from green waste as a resource is fully consistent with circular economy objectives and is particularly important at a time when the UK is moving towards net zero carbon emissions. Production of high-quality PAS 100 product will provide a peat-free organic commodity to support local industries and in advance of a ban on using peat anticipated in the near future. The location for the facility provides an excellent opportunity to provide composting facilities for green waste arisings owing to its proximity to the A1M and other transport links. Importantly, the site is in a rural location that provides excellent access to markets for the compost product. This proposal therefore fully accords with the aims and objectives of sustainable development as defined in the National Planning Policy Framework and as officers have acknowledged in their report. The supporting technical assessments demonstrate that there will be no significant environmental impacts arising from the construction of the facility, a conclusion supported through the statutory consultation process. We recognise, however, that there are local concerns about this proposal. All technical and environmental aspects of this development have been considered in the planning application and by statutory consultees. And alongside this application, we have also applied for an environmental permit which prescribes detailed environmental control measures, including odour and waste acceptance procedures. This is at an advanced stage and we anticipate this being issued shortly. Biffa has worked proactively with officers to ensure that any impacts arising from this proposal are adequately mitigated, and we have made a series of submissions to support the proposals throughout the determination period that will continue to protect local environmental amenity during the duration of operations. As such, it is demonstrated that all technical, environmental and amenity aspects of this development can be managed, and this view is supported in the officer report. We therefore hope that members will support the officer recommendation. Thank you.
Thank you for your presentation. Members, do we have any questions? Councillor Hogg.
So, thank you, Chair, and through you. So it's been suggested that maybe a temporary permission were granted. Would you be amenable to that? And if so, what kind of minimum, minimum that you would be looking at for that?
Okay, so I mean, the purpose of this facility is to service local authority contracts, and typically those are looking at sites with planning permission for horizons beyond 10 years at least, so that they can continue to service those contracts on the basis that they can go on for that kind of period of time. I mean, I think members should be, confident if planning permission is granted, you've got two separate regulatory regimes to control how this site operates in the event that there is instances of unforeseen periods of odour. There is controls in place through the Environment Agency to come down on us essentially, and enforce us to operate the site in a better way. The odour management plan that is submitted with the permit is very detailed. It prescribes, it looks at all areas of the operation where odour could potentially arise from, how those risks can be mitigated, backup procedures. In addition, from our point of view, we do daily odour checks at all of our sites and reporting. So I think it would be the case that is the temporary consent necessary given the regulatory, procedures that are already in place, should planning permission be granted.
But conversely, if you are absolutely confident that your site is able to work within those rules and regulations, then going from temporary to permanent in 5 years' time, from your point of view, from what you've just said, would be a foregone conclusion. So therefore, it would be from your point of view, very little risk.
Well, I mean, that's true, and we're confident of that. But, you know, we also get a lot of complaints that aren't attributed to our activities. You know, and that's, you know, something that could, you know, there's a risk. There's no guarantee to say that we'd be able to get the 5-year consent extended. We would have to reapply and it would have to be dealt with on its own merits. We're confident we would be able to do that, but equally, you know, you don't know. You know, there could be, you know, people who object based on the fact that they are detecting odour that hasn't been recorded or hasn't been attributed to BIFA. You know, I think that the horizons are such that, and the investment is such that the temporary consent is a risk for bringing the development forward. When, you know, it doesn't appear that it's sort of a justified approach at this stage to me. You know, happy to have further discussions, obviously, depending on how we get on.
Thank you. I know it's getting cold, but if you have any supplementary questions, through the chair, please. Councillor Hogg. Thank you. Councillor Hussain.
Thank you, Chair. You mentioned you have other sites as well where you obviously do the same windrow composting. Do you use the same parameters of the 250 metres? And if so, has that led to any complaints coming in because of odour? And also, on the back of that, how do you measure the odour? As in, do you have odour sensors 250 metres away?
Okay, so the first point, I think, yeah, mostly they're in rural locations like this one, because we have a compost product that we are looking to export. 250 metres tends to be a permitting route, so you've got a standard rules permit, or in this case, we've pursued a bespoke permit. And we do have a couple of sites that are in closer built-up areas that are part of bigger waste management facilities that tend to operate very effectively from an odour point of view. Mr. Cutteridge has been to one of our sites in Kilsby. So we do have them all over the place. And now I've forgotten the second part of your question, sorry.
So it was just about whether there was complaints from those neighbours and odour detectors, sorry. Yeah.
I mean, I guess, you know, you can never say it's going to be ever complaint-free, but the point being is if there is, it's how that is then regulated and how we can change our procedures to then mitigate against any potential odour that may come out. But I mean, you know, pretty confident that you wouldn't be detecting odour at a distance from the site. You know, you would say that with any waste operation, I think. But it's the controls that are in place to manage those. In the event that there is a period, then we can change our management procedures, and the Environment Agency would issue compliance scores and require us to do that anyway. I think you're asking about detection as well. So, I mean, it's in the event of a complaint received by BIFA, either through BIFA or through the Environment Agency, we will do a drive around to corroborate that, or the Environment Agency will as well. And then I guess there's a sort of a calibration process for how that works. It's not so much as an odour sensor, but there's it's kind of you know, internal training how we've done that. That's all submitted to the Environment Agency for corroboration and, you know, analysis that, you know, is it attributed to BIFA or not, and if so, why?
Thank you. Any more questions? I have a question. The councils in their address made reference to noise, dust and traffic. What do you have to say to that?
Okay. I mean, you know, again, noise, dust and odour considered in the planning for noise and dust, and also with the permit. So there'll be conditions about how we monitor dust through the dust management plan that will be conditioned in the operational techniques within the permit, just like odour. And then noise has been considered in the planning application. I believe we have a noise condition on there, and we will be undertaking monitoring 4 months into the operation commencing, I believe, for a period to demonstrate compliance. In terms of traffic, you know, it's a sensitive issue in the area. We're not blind to that. The traffic information submitted with the application has taken into account the 270 homes to the south of Iron, Red Kite Farm, Red Brick Farm, yeah. So they have been considered in the cumulative impacts. We had dialogue with the Highways Authority during the submission process, and we've submitted further clarification that they are satisfied with, and consequently they have raised no objection to the proposal. So I think we can, again, similarly manage the traffic.
Thank you. Any more questions? In that case, thank you very much. If you'd like to take a seat at the back. Now, members, any questions to officers? Councillor Hogg.
Just wanted to explore further this idea of a temporary permission for 5 years. I just wanted to hear what officers have to say regarding that, because we've heard from both sides on that.
Yeah, thank you. It's an interesting question. If we want to go down that route, we need to consider if it's necessary. So you might like to consider some of those factors, what you might consider to be necessary. So what do we know about the site and its operation? What's likely to be the outcome? In terms of odour, I think we have a reasonably clear case there from my point of view, is that is an Environment Agency controlled process around that. I'd also like to highlight, especially with odour, that there's what I would call a market control as well. So typically the problems with odour on a compost site will arise when you have anaerobic conditions on site. Now, if you have anaerobic conditions, the likelihood of you being able to produce your compost to the PAS quality standard is minimal. So if you don't manage your processes properly, you're not going to be creating a saleable product. So it's not that's what I call a market control. It's maybe not a planning consideration, but if these guys are in the market to make money from compost, if their site is smelly, chances are they'll go out of business. You know, it's just how that process works. The other temporary consideration that you might have in your minds is perhaps around traffic, because we do have a slight unknown here in that I will be bringing a recommendation for refusal for the landfill extension that's to the east. I'll be bringing that in the new year, is the expectation. But obviously you'll be familiar that there's an appeals process for that. So it could potentially be that application gets viewed differently on appeal, and then you may have made a decision today based on your traffic expectations around traffic movements for this one activity, when in fact there could be an opportunity. How large or small that is, I'll leave that to you. So there could be an opportunity that the landscape around traffic numbers changes in the course of the next year or two. That is a possibility, but I'll leave that to your judgment, I think.
Thank you. Councillor Hogg.
I've just got another question, and it is about transport movements. So this 30 movements a day, although that is an increase on where we are today, it is overall a reduction on where the peak has been because of the number of vehicle movements previously, when it was a much more functional site. Is that correct?
That is correct. Historically, we had 430 vehicle movements per day associated with the site when it was both a quarry and a landfill. Yeah. We had some regularisation applications recently, and the number of vehicle movements is reduced now for landfill operations to 190 for the remaining life of the current southern extension, which runs until 2025. But there is a further period of 2 years for restoration, so there may be a requirement to import some soils. So up until the end of 2027, we have a fairly clear view and understanding of site vehicle movements. I think Mr. Irvin referred to the cumulative impacts that have been assessed, and they have been looked at in terms of the housing at Eye and Red Brick Farm. So I think the only unknown is if this physical extension to the east gets approval on appeal, is the only sort of unknown really. But as far as we're concerned, the 30 movements that would be associated would be, that's a permanent facility, a composting facility, unlike quarrying or landfill, which, although it's long term, it is still classed as a temporary use. So this would be a permanent use of that site for 30 movements, up to 30 movements per day.
Thank you. Beg my indulgence. So, the final thing is that so that 30 movements per day will, in some respects, I'm guessing, will firm up your decision to refuse the other, because without this 30 movements per day, that would reduce by 30 movements the amount of vehicle movements for the second one, if you get my meaning.
Yeah, I think I understand your question, Councillor Hogg. There's a requirement to understand the full cumulative impact. And so if we were to look at the landfill movements in combination with everything else, then we have a clear highways objection to that overall quantum of vehicle movements. When we're looking individually at the compost facility, we don't have a highways objection on that.
Thank you. Councillor Sharp.
Yeah, part of that's been covered by Councillor Hogg, but it's just to clarify my understanding, so you're saying 430 a day. 430 a day is the movements with a current approval for the site up to 2027. So this is adding 30 to it. Is that correct, or am I completely missing the point?
I'm sorry, can I ask you to repeat the question? Sorry.
I thought you may need to. Yeah, so the vehicle movements, you quoted 430 a day is currently in place for the overall site up to 2027, I think, if I understood you correctly. So is this adding 30 to it? But actually the current run rate is well below that. So the approved level would be 460? Or have I completely misunderstood?
Sorry, it is complicated how all these figures fit together. So the 430 figure is the historical figure for when the quarry and landfill was operating. I perhaps didn't make it clear in my presentation, but the quarry has been exhausted. And so the only activity we have there at present is the landfill. That has 190 vehicle movements associated with it. So this 30 would be in addition during the period that the landfill remains operational, which is up until 2027. Hope that's cleared that one.
Thank you. Councillor Jones.
Thank you, Chair. What I'd like to do, and if it's not possible, please tell me, is re-engineer a question from Councillor Hogg to Mr Cutteridge, who, apologies for mispronouncing your name before, is given that there are permitted conditions, we're getting back the previous one, and of course the fact that if there's anaerobic digestion, then there would be odour. How would he feel that there are now, you know, the Environment Agency and, you know, the market forces? How would he feel about that? Because we had this arbitrary figure of 5 years that we could perhaps put a condition on, but would that assuage some of the issues that he feels? Maybe a rhetorical question, but I'd be interested to know.
I'm not quite sure what protocols are, but I think that question is for Mr Cutteridge.
The question actually would be for you. You've made it quite clear on, you know, about the anaerobic and obviously the EA permits, and based on that, making it quite clear that there are further permits and market conditions. I was just, really, it's a rhetorical question perhaps, whether I could address that to Mr Cutteridge, but if it's out of order, then if I've missed my chance, then I withdraw it.
Now we've moved on, so we can't get a response on that. So, Councillor Harper.
Thank you, Chair. Through you, would it be okay for you to just point out where this new housing development is on that map, just for me, just so I've got a feel for that first? In that section there. Right. Okay. Now, okay. Going on from that, add in what you expect that traffic to be. This might be highways. Might have to come on this. You might be able to do it, Alan. I don't know. Whichever. add in the traffic that you expect to be using Ivory Road to get to Fengate, Whittlesea, whatever, to what you've got at the moment with the tip, plus this, are you content that the road can cope with it? Because obviously councillors are saying it's a nightmare, the ward councillors, and to be fair, who better to listen to for the real what's going on the ground. So first, are you effectively, are you content that this road can cope with it, with the new numbers that you're putting together? Thank you.
Thank you, Chair, and through you. I think it's important to note that the assessment for this site has taken into account the housing development, which has been resolved to approve subject to the 106, and also the Red Brick Farm development. Anybody knows that Ivory Road's not an ideal scenario, and there's no scope for any improvement to it in terms of where the existing passing places are and things like that. So we are sort of stuck with what we've got in that area. In terms of the highways considerations, we've obviously got to look at significant residual impact for development and whether there's mitigation that can take place. And boiling in this application, we're essentially talking about one additional HGV into the site and one out per hour during the working day, and we would very much struggle to say at appeal that that is a significant adverse impact on top of the existing operations. You've also got to bear in mind that the existing operations on the site are due to finish in the next 4 years. So after that point, you're losing 190 vehicles or HGVs from that road, and you'll just be left with the 30 per day, as I say, one each way per hour.
Thank you. Any further questions? Okay, in that case, then, if you don't have any further questions for officers, we could move to the debate. Who would like to start the debate? Councillor Sharp.
Yeah, I'll get it going.
Oh, Councillor Harper, you want to go? All right.
Oh, sorry, did I? Sorry, I thought I said Harper. You're going to get me ears.
Councillor Harper, I would like you to start the debate.
Yeah, okay, fair enough. Right. The questions I had have been answered. I understand the 250 metre boundary, and that's written in stone. I've just checked that as well. Not that I disbelieve you, I just wanted to see if there was any other opinion on that. And it is purely opinion. And I understand you've got to go with facts. You know, if we're going to say yes or no to something, we need to have fact, not necessarily just opinion. The road, I'm sure everybody who's travelled down it, it's a nightmare. But again, I've asked Highways for their view on that, and you know, if it's better than when it was 430 a day, then I can understand how you'd have a job defending 200 and something a day. So I understand. But I do have sympathy, obviously, with the, as Councillor Allen has said, with the residents that have basically said, well, you know, we thought it was all over, but it's starting again. So I do understand that. The application of cause for planning policy, reading through it, noise, dust and odour, I always have a problem with that. And I don't actually like the idea of a 5-year, see how it goes. I think that's another one I don't particularly like. I know it's something that somebody could put forward. That's up to them. I think there's enough there to make the decision. Red Brick Farm, etc., Ivory Development Houses, again, Highways are happy. So with what I've heard and what I can see and what I've researched on this, I don't see any reason to go against officers. So I'd be looking, unless I hear differently, to agree with officers' recommendation. Thank you.
Thank you, Councillor Harper. Councillor Sharp.
Thank you, Chair, and for you. Yes, I think I'm probably going to end up echoing quite a few of Councillor Harper's points. Having done the background read through and so on this piece, I was probably more comfortable than others around noise, odour, etc. Given the cover from the IPPC permits and etc. The fact that that's a requirement that's well established in environmental law and environmental management, and companies such as Biffa no doubt are well used to complying with that. So really my only concern was about the traffic and the transport piece, and hearing from residents, interestingly though, that from the residents their concern was more around the odour piece and less about the transport, but I guess that's now clarified by answering them questions in terms of numbers accessing and egressing the site and what has been happening historically, and because that's well below. So on the basis of all of that, I'm reasonably comfortable with the application. I mean, just to pick up on one last point, Councillor Hogg and others, that there's been mention of the 5-year plan, a 5-year temporary granting of the application. I think, and it's absolutely necessary, we should very much drive ourselves away from that and push that out of our minds. I mean, certainly, if I was a business and I was Biffa, and we've heard them answer the question, 5 years could make a distinct difference to their business case, because it does leave it as a what if. Yes, okay, they will do everything they comply, they need to, because the IPPC part of the environmental requirements, but how do they build a business case on a what if that it could be taken away in 5 years? They've got no control over that. So I think we should shy away from that. Thank you.
Thank you, Councillor Schwab. Councillor Hogg.
Thank you, Chair, and through you. So I think that, we've kind of explored the 5-year temporary suggestion. I'm not sure that it particularly has any legs. I think the presentation by Mr. Jones was superb, and the briefing that we got on site again was very, very good and gave us a lot of detail, probably more than we actually needed, but it was actually, it was really good to understand the whole picture. So I thank him for that. So I'm convinced, I have to say, because the reason we have officers is because they know their onions, and they know what they're talking about. I'm convinced that the smell is probably not so much of an issue, or an issue even, because as he's rightly said, that ultimately if it starts to stink, essentially they've got a product that needs to be thrown away rather than something that they can sell. So it's commercially something that is going to take care of itself. I think that if there are issues around the whole thing with the environmental agency will step in well before 5 years anyway, and so therefore I don't think it's something that we need to put in place. So there are times when it is appropriate, and this is not one of them. But we've explored that avenue, and we've come up with an answer on that. I do think that this application, with the the movements, the 30 movements a day, is actually small fry in comparison to where that development has been in the past. And I think it also helps with the decision to reject this new application, this other application, and so therefore by perversely, that by rejecting it, we might actually put in jeopardy that decision to refuse the second. And I think rightly so. I think people in the area would given the choice between the two, this is the one that they would prefer to have. Albeit maybe the ones that are slightly closer, maybe not so much. I don't know. But ultimately, I've not seen anything that would direct me away from officers' recommendations. So, fortunately, I'm going to go with those approval, for approval, basically.
Thank you, Councillor Hogg. Councillor Jones.
Thank you, Chair, and through you. Anybody who knows Ivory Road knows it's a nightmare. And in my previous life as a driving instructor, I think everybody should be made to get down Ivory Road, because it's a test route and people have to learn to drive on that road. So it goes without saying, I think all of us recognise the issues. As far as the, and again, I'll sort of come back, and I hope that whilst I will go with officer recommendations, I just hope that Mr Cutteridge is somehow assuaged, his fears are assuaged that the EA and market forces will, you know, perhaps head off some of the concerns that he's got, and he's got right to redress, you know, through them, should that not be the case.
Thank you. Anybody else? What I'm going to say, in addition to what you've said, Councillor Jones, is that BIFA is a reputable company, and I'm sure they're going to live to their expectations, and any concerns that the neighbours have, they will address them. They've got an order management plan in place, and other regulatory bodies are in place as well. So there's a check and balance there. So I think that I will, you know, avoid any fears. So I'm quite confident on that. So if we are end of the debate, we could go for a proposal. Who's willing to propose? Councillor Jones.
I'm willing to. I'm going with. I'm suggesting that the committee goes with officer recommendations on this issue.
Councillor Hogg. You happy to second? Okay. All those in favour? Against? None. Abstention? None.
Thank you,
Can we give the
Chair.
result?
That is 10 in favour of the officer recommendation. Councillors, Councillors, I think
Chair.
you need to.
Yeah,
I think you need to at least discuss it if it's on the agenda, or
Well,
as the chairman said.
Phil has
defer.
said it's going to take him 5 minutes.
Or less.
Or less. So, shall we give him that opportunity then? Councillor Fitzgerald? Okay, let's go with it then.
Okay, thank you, Chairman. Through you, I'll do this really quickly then. So this is the Appeals Quarterly Report covering the period July to September 2023. We've got we've improved our record of the number of appeals that have been allowed. So there has been 6 appeals during this period, 5 of which were a result of delegated decisions, 1 of which was a committee decision. 5 of these were dismissed, 1 was allowed, and you'll be glad to know it wasn't the committee decision that was allowed, it was a delegated one. So I'm just going to mention the 2 cases, one which was the committee decision, one which was the one that was allowed, and any lessons learned. So the committee decision was relating to change of use of a piece of land to a domestic garden at Thornhaugh. And as I said, committee went with officer recommendation on this. It was dismissed at appeal, but not for all the reasons that it was refused on. So it was refused on the principle of development, with it being beyond the red line envelope of the village, as well as character and appearance, and finally on amenity grounds. Now, the amenity reason was upheld. The inspector agreed with that, but he didn't agree, or he or she didn't agree with the other reasons. Particular lesson on this one is in relation to development beyond village envelopes. The local plan is very clear. Development beyond village envelopes is restricted to very specific categories of development. However, the inspector interpreted this as being built development rather than things like extension of a garden, particularly where there's no harm to the character of the area. So that's a lesson to be drawn from that. The other appeal which I've mentioned, this one was this related to Church Street, Church Walk, sorry, 4 flats, highways and amenity was refused on. In terms of highways, some amended plans were submitted with the application, and that was with the appeal, and that was resolved. Amenity, the inspector took a different view on amenity on this one, that it wasn't an issue. There is a lesson here in that we've noticed inspectors' decisions over the past few years have been gradually getting more and more lax on amenity issues. So things that might have been upheld at appeal 2, 3, 4, 5 years ago on amenity grounds are now being allowed. So clearly the government is taking a more lax view on what constitutes unacceptable amenity issues. And yeah, that rounds it up. Thank you, Chair.
Thank you very much. Any questions? No? Then that concludes the meeting. Thank you very much for everybody's contribution. Thank you.